Okay, how about we just do that? There we go. And again, you guys never have to give me. I don't want anyone to thank you, Nurse Amy. I don't want anyone to think you guys ever have to give me. Oh, he is? Okay. I figured out. Okay, so I was just sent this, and then Black Widow sent me the forms from yesterday's filing. I think I have it open, Kristen. Is it just the like 1.5 pages? Is that what it is? Let me double check and make sure I haven't got anything else. Yeah, I have it. Okay, so we'll read this first. Oh, why did it go small? That's what she said. Just kidding. Okay, so this is from today, May 2nd, 1:30. Nature of proceedings: request for orders hearing filed. The following parties are present for the aforementioned proceeding. So 2K, Bri, both attorneys. The matter is called for hearing. All parties appeared via LA Court Connect. The matter is set for evidentiary hearing on August 22nd, August 25th, and August 26th at 1:30 p.m. Each date in this department. Thank you, guys. Briefs to be filed on 7/18/25. Counsels are to meet and confer regarding exhibits and evidentiary hearings. Neither party is to live stream any medical procedures of the minor child. How sad is it that we even have to put that in there? Good. I think that's absolutely what's best. You know, I'm only reading the court hearing stuff because it's public information and everyone wants to know, but I don't think it's good for either parent to talk about it. Okay. Let me see. I just think that's sad that we have to tell people not to live stream a medical procedure. That's crazy to me. Petitioner, which is John, is ordered to notify respondents of any medical appointments for the minor, which makes sense. The court sets a case for trial readiness conference July 24th at 8:30. This will be a long one. Pending further orders and pursuant to agreements of the parties this date in court, respondent is to have professionally monitored visits with the minor from May 10th, 2025 till May 17th, 25. June 20th through June 26th, July 3rd through July 10th, and August 4th through August 11th. Visitation is to be monitored by keeping the peace or other such professional monitors and agreed upon parties. Respondent may select the number of hours and location in Dallas County for the visit to take the peace. Respondent is to provide at least 24 hours advance notice of location to petitioner. Respondent is ordered to comply with the rules set by the monitor. And that was all from today's hearing. So I will say this. I did see a couple videos of people saying, oh, she gets visitation, she gets them for a whole week. She doesn't get them for a whole week. There's absolutely no way that you're going to have a monitor with you 24/7 for 7 days. Oh, I'm going to go back over it. So no, you didn't miss nothing, love. I'll make sure you guys all get the information. It literally just says, it just gives the dates of when the next court hearings are, evidentiary hearing, and talks about her schedule. So she gets them for 7 days. She doesn't get them for the 7 days. She gets them for as many hours as she wants in the 7 days, but it can't be overnight, right? Because she has to have thank you, love. She has to have somebody there with her. And mind you, it's $137 an hour too. And she has to pay for it. So I know people are running around talking about she's going to have them for the whole week and they can do whatever. No, it doesn't say it's at a facility. It just says it has to be monitored. Let me go back over it again just in case. Okay, so pending further order and pursuant to agreement of the parties, this date is open in court. Respondent is to have professionally monitored visits with the minor from May 10th through the 17th, June 20th through the 26th, July 3rd through the 10th, and August 4th through the 11th. Visitation is to be monitored by keeping the peace or other such professional monitors as agreed upon by the parties. And then it says, respondent, who is Bri, may select the number of hours and location in Dallas County for visits to take place. I know when she was talking to Jordan, I saw the video where she was saying, I can take him wherever and I can just go and do whatever with him. Yeah, that's not how that works. We're just getting started, love. We haven't really gone over much of anything. And respondent is ordered to comply with all rules set by the monitor. Right? So the monitor is not going to just let you go all over the place. And just remember, again, she has to pay for that. So that's basically what came out of today. Thank you so much, Jackie. That's all that came out of us today, is just setting the dates for evidentiary and the trial, and she gets him those months, and it has to be monitored, but it does not have to be in a facility. Love that TikTok shop. She said they don't have to be. Oh, absolutely, Kelly girl. That's why I said I don't believe anything she says until I see it on a court document or I hear from 2K. I don't believe it. It absolutely has to be. It has to be monitored. She has to pay for it. She's responsible for the cost. It does not have to be in a center though, and that was the thing that she said before that she didn't want. She didn't want it to have to be in a center. Yes, I think I can. I should be able to figure it out. I'll try to figure it out. Only Bri will be. What did I say? Only Bri will be present for the visits. Yes, and no one else can attend. Yeah, she says a lot of stuff. Now she may have heard. Thank you, Lisa. She may have heard I have him for 7 days. She may have heard that, but she didn't listen to the whole thing. Yeah, you have him for 7 days for the number of hours you want, not overnight, and it still has to be monitored. Your monitor will be with you at all times. I don't even understand how you could, like, being at an In-N-Out parking lot in a car for a couple hours. How are you supposed to? I don't know. Yeah, that was the paper from today. That's basically just the notes. I'm going to go into, I think that's in here. I was sent this today by Black Widow, so we're going to go over that. I don't know if it's in here or not, but I think that this is where it is, because this was done by her attorney. So, but I did want to go through today's stuff. Thank you, Grandom. Level 14. I did. Thank you so much. Yes, it has to be a licensed monitor. Well, no, actually it says, hold on. It did say license. Hold on, let me read the terms again. Because I think it said, hold on. Okay. Okay. Through the 11th, visitation is to be monitored by Keeping the Peace or other such professional monitors agreed by. So yes, it does have to be a professional monitoring company. It cannot just be a person. So it can't be like her mom, a friend, whatever. It has to be a professional center. So again, she yaps, and she has her little yappy people that yap along with her that just spill a bunch of misinformation, which is why I will not do that. I will never report on anything until I hear from 2K or I see the court order. That's it. That's all. Yep. And people always come in and they always come at me because, well, Bri said, well, remember our last one, we had a drinking game? Drinking Diet Coke TikTok, because that's my favorite, right? And I kept saying, no, you guys, she's still going to have court today. Hello. There was court today. Yes, she has to pay for it. It's $137 an hour. Angie, she's not allowed to be alone with him, right? She cannot be alone with him. It has to be professionally monitored at all times. Oh my God, I've been so mad since she spoke. Did she come on and speak? Or are you talking about just the phone call with Jordan? Yeah, okay, I'll do it one more time. And then I'll do it a couple times through, but I do want to get into this. I already took my Advil because her attorney did it and it gives me a headache. So I'm only going to read the last piece that talks about the monitoring part because the rest of it is just dates. No overnights. She cannot do overnights. So it says, pending further order and pursuant to agreement of the parties, this date in open court. Respondent, who is Bri, is to have professionally monitored visits with the minor from, and then it has the dates, right? May 10th. I'm not going to keep going through the dates, guys. That's a lot. Plus, I would like for her to have some privacy, you know, if she can keep it private. And then August. Visitation is to be monitored by keeping the peace or other such professional monitor as agreed upon by the parties. So it cannot just be a friend. It can't be a family member. It has to be a professional place. And then it says, respondent, again Bri, may select the number of hours and the location in Dallas County for visits to take place. Respondent is to provide at least 24 hours advance notice of the location to petitioner. Respondent is ordered to comply with the rules set by the monitor. No streaming. Well, it actually only says no streaming during medical procedures. Which again, I think is so sad that that has to be put in there. It says petitioner is ordered to notify respondent of any medical appointments. Neither party is to live stream any medical procedures of the minor child. Yeah, Bri likes to tell a lot of things. I really think that's why she doesn't like me, because I don't fall for her crap. And everyone else like listens to what she says. Not everybody else, but there's a lot of people that listen to what she say and just put it out there right away. I'm not going to do that. Yeah, I'm just not going to do that. She cannot stream with the bond. No, absolutely not. No. Now, they may allow her to take some pictures and stuff. And again, that's, thank you, love. That means so much to me. That has to be agreed upon for them. You're out. Sorry, have to, a lot of people. And again, she has to pay for it. It's $137 an hour. Okay. So let's say she even just, thank you so much. Let's say she will do 4 hours. That's $548 an hour, or a day, if she chose to do 4 hours. And then it's for 7 days, that's $3,836. Not including airfare and hotel, food, everything else. That's if she wanted to do 4 hours. Oh my God, Emily, can you imagine? And you know they say the most ruthless, craziest shit on there. Yeah, it's a lot of money. That's why she has to choose how many hours and how many days. She doesn't necessarily have to do the whole 7 days. I'm good, love. How are you? But yeah. It doesn't say no overnights, but that they're not going to do overnights, because a monitor can't just sit there and watch you sleep. It doesn't draw it out there, but it does say that they have to abide by all monitor rules. I can almost guarantee you. Here, I'll look it up. What's it called? Keeping the peace? Let's just look it up real fast. Keeping the peace monitor. Keeping the peace. Program. Okay, so it says keeping the peace parent monitoring program generally refers to parental. Oh, I don't want that. I want to look at their actual site. I don't even see a website for them. Well, I'm not going to search on too much. I don't like to have my head down when I'm trying to talk to you guys. Okay, so I'm going to recap this one last time, and then we're going to go into this. Oh, it's $167 an hour? Oh, crap. So basically, court today, they got new court dates set up. Visitation starts in a couple weeks, and they'll be in Dallas County. They have to use keeping the peace or another professional supervising program. She has to pay for it. And I got you, girl. There you go. So yeah. So she'll have to pay for it. It's $167 an hour. I thought it was $137. There you are, love. Thank you. Okay. So if she did 4 hours a day, she did 4 hours a day for the whole 7 days she was there, it'd be $4,676. So, and that was all that really came out of today's. Now, this is what was put up today. I know, unless you guys want to play it. Now, I only drink my Diet Coke here, but if you guys want to, we can play a little, you know. And every time I have to say that no, she actually does have to have supervised visitation, then you guys take a look and we can see who's going to be at the end. I think so, because there really wasn't anything besides the fact that she has to maintain supervised visitation. Yes. Oh, there you go. Thank you, Beth. Yeah. So that's it. Now we're going to go through and read the court docs from yesterday. What did you say? You have more viewers than 2K. Oh God. don't say that. You're like, Angie. All right. She gets to choose how many days. She does not get to do overnights. Again, it says she gets to choose the hours because she has to pay for it, right? So she gets to choose how many hours. She gets to choose where she wants to have them. But again, it's not going to be overnights. Not that I've heard. I haven't been on, though. I just came from work and had to reapply some eyeliner and mascara because somebody had me crying. Boo-hoo, ugly crying. Well, at least there's that. She's forced to be off her phone. I always say that. I think that that's such an important... I really hope that she takes those as that time as that she needs to. You know what I'm saying? Thank you, love. And really just let herself think about things. I think that's in here. So we're going to start reading that now, okay? I just feel bad. I don't like to have my head down. But I want to thank everybody for, you guys are so amazing. All the gifts and everything. Remember, you guys never have to gift me, but I so appreciate them. I just don't want to have my head down and miss you. Okay, here we go. So this is Respondents Council, which is Bri. Supplemental Declaration supporting respondents ex parte, RFO, etc. Okay. I, Lindsay, let me write this down again, because I get their names mixed up. So Lindsay is Bri's, and Taylor is 2K. Okay. So I, Lindsay, hereby declare as follows. I am the respondent's attorney in the above titled action. I offer my declaration in lieu of personal testimony pursuant to the codes, whatever. I'm not going to read all that. I offer this declaration in lieu of my personal... Okay, well, we just did that. Petitioner and respondent were in a dating relationship on and off for less than 1 year and share one son. His information, which I will not read. The purpose of this supplemental declaration is to update the court as to where we are with our DVRO/move away trial preparation since 4/22/25. Ex parte RFO was filed at Judge Nord's direction, and as well as Brianna's supervised visits with Baby W. And again, this is the one that was filed yesterday. Wait, what's happening? What's this? Oh, I gotta turn my things off. Yes, I keep... Hold on, let me turn this off. I keep saying... Yes, you got... Oh my gosh. Why am I getting so many requests? Oh. Well, happy birthday to the baby boy. Okay. 2. Request. We respectfully request the court to order The 5/7/24 move away RFO and the 3/27 25 DVRO hearings to remain combined as a combined hearing in front of 2C. Then continued to sometime in late June to allow us time to receive documents back from our subpoenas issued to LASD, LAPD, and LAPD Hollywood Division on 4/23. Wait, what is she trying to say? My bad / hearing conflict? Is she trying to say... Wait a minute. Is she trying to say my bad? I'm so confused. It says my bad / hearing conflict, dates in June. Oh, her bad dates. Oh, that's what she's trying to say. Okay. Are June... Anyways, I'm not going to go through the dates. The professional visitation monitor to be used per the 3/24/25 orders for professional visitation for my client and at Keep It Peace. So even her own attorney, you guys, is still requesting, is still stating we're still going to stay with supervised visitation. So it blows my mind that she's on here saying, nope, I don't have any more supervised visitation. I just get to keep him for the 7 days and I get to go all over and take him over. No, you don't. No, you don't. KJ, thank you, love. I retire and I get a caterpillar come play music for me. Yeah, she doesn't get to do that. All professionally monitored visits for my client and BBW to be exercised in Dallas County, Texas, per the 3/25 orders, shall be exercised in a private home setting or a public place, not a visitation center. Now, this is what her attorney is requesting. I should have read this first, but you guys want to hear the other part. Not a visitation facility. And they did get that. She still has to use the Keeping the Peace, but it does not have to be in their facility. It can be somewhere else. Brianna's professionally supervised visitation with BBW, supervised by a monitor from Keeping the Peace LLC, shall be on the following dates. She puts the schedule there. All 4 to 6 hours per visit. So why... Listen, even her own attorney is asking 4 to 6 hours. Why does she come on live? That's what kills me. Why does she come on live then and say that she has him for a whole week, no visitation, no monitor, or not visitation, but no monitor, and she can go wherever? That's not true. Absolutely drives me crazy. And then people just put that out there and run with it and then just put out misinformation. It's terrible. Oh, holidays are more... Okay, got you. And then so they put their dates out again. I'm not gonna read the dates because I feel like she'll put it out there, but I don't want to because she needs to have some privacy. Number 3, hearing last week at the 420. Anyways, I'm not gonna read the dates, guys. Move away trial hearing in Department 2B with Judge Nord. We exercised our statutory continuance on the DVRO. We advised the court I had just subbed in on 4/15 and was working diligently to issue subpoenas and prepare for trial. Since it takes a minimum of 30 days to receive records once a subpoena is issued, unfortunately usually longer when subpoenaed LAPD or LASD, which is who we are subpoenaing, I asked the court if we could move the 5/2 trial date. Judge Nord advised he was just covering the hearing for Judge Bershon in 2C, and because 2C was closed on 3/27/25 when the DVRO was filed, and he could not make any changes to 2C's calendar. Thank you guys for keeping that information up there for me. I so appreciate you guys. Thus, he recommended we file an ex parte RFO with 2C for a continuance on the 5/2 hearing. He said he would make note of the need for a continuance in the minute order to allow time for the subpoenas. When we asked Judge Nord if he could order specific days for Brianna's supervised visitation pursuant to 3/24 orders, due to our ongoing issues with trying to arrange for those with John, he said he would not modify those orders, as that needed to be done by our home court judge. So, again, even the stuff that she put out the other day was wrong. I'll just keep reading. He did advise the parties that withholding visitation and or making visitation difficult can be a sole basis on which a move-away RFO may be denied. Absolutely. And And this conduct can also be sanctionable upon, etc. Which is true, right? We always have to make sure that any type of it, like there's no parental visitation being withheld. They do need to make it as easy as possible for each other, both of them, right? He needs to be agreeing to the days. I think now that it's like written out very clearly, remember the other day when we went over, I guess it was last week, we went over the original court orders, and it's in one box, but you only had 2 boxes to check, right? So it was box professionally monitored / facility, or no monitor. That's confusing. So he's taking it as it's going to be in a facility. Thank you, Kim. He's taking it as it's going to be in a facility, and she's taking it as it just has to be monitored, because that form is not clear. Now it is very clearly written out, the exact dates. Thank you, Tammy. The exact dates. She gets to choose the times and the amount per day, and she pays for it. So now it's very clear. Yes. Okay. So number 3, I did that. Exhibit A. Okay. Per the court's advice, we immediately notified an ex parte RFO for the following day to Miss Budnick after we finished court. Judge Norris ruled on 422 ex parte in chambers and denied a request for an ex parte basis, noting these issues would need to be handled our home court judge on 5. She repeats so much stuff. Just so you guys know, this is her writing it and repeating it. It's not me just rereading the same stuff over and over. I just want to make sure I'm clear on that. For the 1st time, I am right. Okay, number 4, subpoenas. On 4/23/25, we gave notice of the 3 subpoenas attached, Exhibit C, to LAPD, LASD, and Hollywood Division RE, the alleged kidnapping encounter on 3/24 and 3/25. Now that's going to be interesting. I wonder if her judge, or not her judge, sorry, if her attorney like went and watched that stream. You know what I'm saying? Because her attorney could have went and watched. Wait, what? And you checked like 3 times. I never saw. What? No way. I'm sorry, love. I did come on a little bit late. And we're just getting started, so you're good. But I'm wondering why she would have wanted the police, like the subpoena for the police to come. I feel like that's not going to benefit Bri in any way, shape, or form. Right? The way that they were leaning over the balcony and mocking the police, and the things that they were saying, and the way she drug it out for 2 hours. Just saying. It's me crazy. Okay. We have arranged for personal service of the subpoena on these entities for 5/2. While the production date is 5/19, I am almost certain we will not receive the record by then, because we request police reports, 911 calls, videos, and audios, among other recordings. And we know there were several officers dispatched. Absolutely, there was a ton. There was a lot there. It doesn't say she can't stream him. It just says you can't stream medical procedures. We'll go back over today's findings. Just really fast for anyone who just popped in. Today's findings today were just that all they did was set out the future court dates and the dates that she gets supervised visits, and it's still supervised visits. She still has to pay for them 4 to 6 hours a day. That's it. She does not get to, and it has to be, she has to let them know where. So like say she wants to take them to the zoo. She could probably take them to the zoo and they'll follow her around and watch her, whatever. But she doesn't get to keep them overnight. She doesn't get to just go from place to place. She has to pick a place, and that's where they'll stay for whatever that is that day. I know she, listen, that's why I tell you guys all the time. She'll tell you anything. Don't believe it. Until I see it on a court documentation, or I hear from 2K, I don't believe it. That's, I tell you. Listen, remember that my live on Wednesday, how many people came in and kept calling me a liar because she said that they didn't have court today? And look, they had court today. Thank you. Okay. That'll be interesting to watch those things, though. Okay, obtaining that much body cam footage is going to take these places sometimes to get it to us. We will also need to transcribe what we plan to use in court. Once we have a new trial or a date for trial, we will serve appearance subpoenas, blah, 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 blah. So basically that's just asking for more time for the trial. Discord records. So I think that's what you guys wanted. John's 32725 request for a DVRO was again based on alleged online bullying and a kidnap claim. Is it a claim? Ma'am, is it a claim? There's a court order that said that the baby needed to be in Texas. Your client took him to California. He was then able to get a order from the judge that she, in fact, from the judge, said that, and she refused to give him back. She did not take him back to the meetup spot at the police department at 12 o'clock that afternoon. She said it needed to be closer for her or they can come get him. And that's what they had to do. So her poor baby had to sit there for another 2 hours. Okay, this bitch is going to really irritate me. For 2 hours while she was talking to the police. So it's not a claim. It's not a claim. Okay. For all these reasons, we think... Oh, no, I already read that. Okay. Nearly every pleading to date that John has filed, he has requested orders related to not talking about the case online, not disparaging one another online, and not posting Baby W online. Yet he continues to repeatedly break all of the orders that he requests. Listen, lady, I truly feel like she's not watching any of this. She's really not watching anything that's going on. Bri comes on a regular basis and talks horribly about John. John will answer questions, but he also defends her. He defends Bri to the highest statue. He has gone online and cussed other what do they call, creators out for doing, again, the painting. Why would you want me to throw darts and tomatoes at it? I think it'd be funny. He's told other people, do not talk bad about my son's mom, because it will not end well for you. Do not talk bad about my son's mom. So he's kept it cute. He's kept it classy. I don't see anything that he's done wrong in that situation. Now she comes on a regular basis and talks bad about him. Very bad about him. This lady. I would love to be a fly on the wall in that courtroom when she actually sees all this stuff come out. Anyways, there are current orders in place not to disparage online and not to post. Oh my gosh, the repetitiveness. We now know that John is using a Discord channel to encourage his fans to go after Brianna and those connected to her, including myself. That's a lady. So we are seeking a order to subpoena Discord for these records. John cannot continue to make these bullying claims. This lady. And file 2 requests for DVRO on this basis while he is orchestrating this online, both publicly on TikTok and Snapchat and privately through Discord. Lady, listen, what's your name? Lindsay, come here. Just me and you, love. Before you make these type of accusations in court, you should maybe just watch 10 minutes of one of your client's videos. That's all I'm saying. I'm not asking for a lot of time. 10, 15, maybe 15 minutes. That's all. It'll help you. Trust me, it's going to help you. Oh, I don't know what would happen if it got deleted. I don't think he has anything. I mean, I'm not in his Discord, so I don't know what's happening over there. But I can't see. I just can't see why would he do that. He has nothing to gain. Again, he doesn't have to say anything. He doesn't have to disparage her because she disparages herself. Right? So I've said that since the first video I ever did back in October or September. I said, she's making this very easy for him. All he has to do is sit back and just take care of the child. Right? And she just continued to go downhill. I don't know. So he doesn't need, and if he starts doing stuff like that, like trying to delete Discord or messages stuff, it's gonna make it look bad on him in a way like, what were you trying to hide? You know what I'm saying? Like if you watch the Karen retrial, you guys will know they're being blasted right now because they were deleting messages and stuff. Okay. She's a hoot, this lady. Number 6. In the last month, John's private Discord channel... Well, thank you, Jen. John's private Discord channel messages... I can't even make this stuff up. Can you guys see that? She put in... it says, in the last month, John's private Discord channel messages, and then in parentheses, she put, the real supporters. This lady. Were leaked everywhere online. Now, I know I'm not online a whole bunch, but I haven't seen not near one of them. I don't know. This Discord is full of middle-aged women and John. Who are you calling middle-aged women, lady? It contains non-stop chatter, instigating by John to pit people against my client and those connected to her. He encourages his fans to locate Brianna's BFF address and cause harm to her. Right. Listen, this motherfucker and her stupid private videos, take your ass elsewhere. How many damn things she got? This girl, Lena, was the person who came to LA. Why is she going to say it like that? This girl, Lena. Who is she? Why? Like, anyways, this girl, Lena, was the person who came to LA to help Brianna right after Baby W was born, when John deserted them there. Oh, I can't wait. Deserted him there. Thank you, Sven. Again, lady, I think you need to go watch that. Additionally, the way he speaks to these women, who are all his biggest fans, is just deplorable. Listen, if they're not complaining, why are you complaining? Again, I'm not on Discord. I don't know what happens over there, but why is she... Thank you, love. You're so pretty. Why is she complaining? Why would that need to be brought up in court at all? What does that have to do with this case? Nothing. See, that's the difference between 2K and Bri. Thank you, Linz. She has to find anything she can to try to give her client an up. He talks to middle-aged women and he says bad things to them. What does that have to do with custody? But his attorney doesn't have to do that because Bri puts it all out there for just to make herself look bad. You know what I'm saying? Okay. That's my opinion. And very much like how he spoke to Brianna during their relationship. Hold on, let me read that because I stopped in the sentence. Okay. Additionally, the way he speaks to these women, who are all his biggest fans, is deplorable and very much like how he spoke to Brianna during their relationship. Allegedly, it was within the same Discord channel that John was encouraging his fans to contact me. Excuse me. Anyways, on 4/23, another Discord channel of John's supporters began posting my personal information. This was immediately reported to me by someone in the channel, and within hours that day, the email and calls to my office started. No one has contacted me on behalf of my client. Every single person who reached out opened the call or email with some indication of being a John supporter. Just between 4/23 and 4/25, I received 20 emails to my firm email address and 4 calls to the office. Now, we can't control what people do online. I was just going to say the Holly right. I did hear John say, hey, I heard people were putting it out there, so don't do that. Do not contact her. Don't do that. He did say that. But again, we cannot control what the people who follow us, what they do online. She acted like she got bombarded with hundreds of calls and emails and whatnot. But how would he, even if it was after the fact, how would he know it was even happening? He couldn't. Why would you just come on and say, please, you guys don't contact the lawyer? Why would we even think somebody would do that? No. It was easy to identify who these people were based on their email addresses, phone numbers, and the fact that some of them even signed their full names in the emails. None of them were from California. A handful were from Texas, and the rest were from other states around the country. I've had multiple high-profile clients throughout my career, mainly reality TV stars. That explains it. And never have I experienced anything like this. I have never once been contacted by fans of those clients, and certainly have never had the opposing party encourage something like this. I hope she has verification of that, because that's disparaging to say. If you don't know that he actually told people, please contact her, if you don't have any evidence of that, if that's not in actual Discord stuff that came from him, honey, right? Walking Karma, listen, lady, I can tell you all about it. I'll tell you about it. Number 8, John is not contradicting his claim of being bullied online when he is the one bullying Brianna. Okay, let me finish reading, sorry. Bullying Brianna online, but continues to violate the order he repeatedly requests. Again, I hope there's verification of this, lady. What I see, now granted, I'm not in his live all day, every day, right? I'm not in there. All I've ever seen him do, though, is stick up for her and answer questions. That's what I'm trying to figure out, is when has he bullied? Again, you're making some big accusations there, Miss Lindsay. I hope you have something to counteract that. She just blows my mind. Like, it's not that I'm annoyed. It's like when I see an attorney write something like that, if there's no verification of it, I'm like, that could bounce back on you, lady. Like, why would you do that? I would never write something that I don't have verification of. Now, I don't know that she doesn't. Again, I'm not in Discord, so I cannot speak anything about it. Just last week, John posted at least one picture and a video of Baby W to his Snapchat stories, while he simultaneously denied my client the right to take private pictures and videos of Baby W for his birthday, while she spent with him at a visitation center for 4 hours. Lady, she did get a picture. And yeah, he posted a picture and a video of his. So I guess this is where I do get kind of frustrated. Like, it's a damned if I do, damned if I don't type situation for her, right? Because she wants all of that, the praise for Brianna for getting all of this stuff and whatnot. And he did such great. She bought the stuff. He dropped it off. She dropped it off with him. He wrapped it up. He put everything together, made a cute little video, sent the pictures to her. So she got all of that too. So you want her to have it or you don't want her to have it? Because right now you're confusing the heck out of me. I'm going to have to take more Advil for the day's over. I'll tell you right now. I keep my Advil right here on deck. That made no sense to me. Made no damn sense. Can't even post a picture. Anyways. The facility rules, which we were... Thank you, love. We were all sent on 4/24 via email. Do not allow the use of cell phones during visits, but there is an exception to this rule. The only exception to video recording, audio recording, or photography is by written approval of both parties. Ma'am, I would like to ask you another question. Since this was their first visit, you chose this center for them to have like a couple days after their first court date. How would they know that? And John asked when he picked him up, he was like, did she get a picture? No. And he says, can you take him back in there so she can get a picture? And they did. So what do you want him to do? Bri also didn't ask. Right? So both of them are learning the rules as they go. They just got the order. How are they supposed to know? I am. Guys get so flustered. Thus, I emailed Miss Budnick that day before 1 p.m. and said, can you please see if John will agree in writing for Brianna to take pictures and videos with Baby W and of him opening his gifts during his birthday visit. I already told Bri that if John says yes, these pictures and videos cannot be posted online. I don't think this first birthday is what anyone expected it would be, but nevertheless. Bri wants to document the memories to look back on in private. I never received a response to my email. Exhibit D. Again, if they didn't see it, like what are they supposed to do? She got the picture, okay? Number 9. Per the 4/26/25 report from the visitation on winter... Oh, God, Baby W's birthday. It's so hard when I'm reading it because I'm just flowing. Baby W's birthday tended to attached Exhibit E. At 1:57 p.m. at the end of the visit, while returning W back to John, he informed me Bri could take a picture with W due to it being his birthday today. My client feels as if John's conduct illustrates his desire for control, not to have, oh my God, a healthy co-parenting relationship. I'm going to keep reading. Listen. I don't understand what's happening with all these spam. Healthy co-parenting relationship with her. He denied Bri the right to take a picture and video of their son during W's birthday visit in advance of that visit, while posting W against his own court order to the socials that very same day. To the socials. First of all, again, lady, I need Diet Coke. On 4/29, in his midday live on TikTok for 15 plus minutes, that was solely about the court case and my client, he explained, this isn't disparaging. This is correcting. 100% correct. I was in there. He was correcting your client's misinformation. I did let her take a picture with W on his birthday. And that was not bare minimum, because she wasn't allowed to. And I said, you can have a picture with W for his first birthday, but she didn't tell you that. Correct, she didn't. She still, until he said that, she still continued to deny the fact that she was able to get a picture. Where is he wrong? Just curious. When John's fans do not like his conduct towards Bri, he regularly attempts to gaslight her in this way online. This lady, Jesus Christ. Number 11. Similarly, in the same live, he said, and then she also told you guys that I picked the times. No, I didn't pick the times. So then you guys started calling me a calculated narcissist. I didn't pick any times. It appears John did, in fact, pick the times, per the monitor's text to Bri, attached Exhibit F. The slots offered to Bri were during the regular nap schedule of a 1-year-old baby. Well, how would you know when his regular nap schedule is? Hi, AA LAW TOK. How are you, love? You can come up if you want to. If you want to help me out. No. Let me see. My client was not going to complain and took what was offered. However, it is hard for her not to feel like these are calculated choices when John posted all day on 4/27 from Winter's birthday. Oh, there she is. For Winter's birthday party at his mom's house and on Baby W's actual birthday. He was seen on a video sleeping on John at an evening dinner at a steakhouse. Hi, love. How are you?
Hi. Oh my gosh. I have missed you. I was thinking about you all week and I kept missing you, but I had this really long court situation. So anyway, but I'm here. How long have you been on?
About an hour.
Oh,
yeah,
for a
I'm
while.
just reading. Yeah, I'm reading. I'm on number 11 of the orders that they did the other day.
Oh,
that her attorney did. It's her. Hello? Sorry, I got a phone call.
Yeah. You went out for a minute.
Yeah, I got a phone call.
Oh gosh, I miss
I know. So did you see what happened today?
I'm just pulling it up right now. I see that there were some orders entered today, but did it get pushed out?
Yeah, it got pushed out, and then she still has to have, they set a supervised visit. She still has to use keeping the peace 4 to 6 hours a day with the monitor. But she's saying that she gets to have them for the whole week. She can go anywhere she wants to, but she can't.
Oh, geez. Of course she's doing that, though. She's just got to be rage baiting, you know?
Exactly. Peacemaker, that is absolutely 100% not true. She still has to use keeping the peace. They can only have 4 to 6 hours a day. And she has to pay for it all. It's like $160-something an hour. So, okay, I'm gonna keep reading so we can get through this, and then we can chit chat. Number 11. Similarly, I just read that. Hold on, I'm all the way down here. My client was not going to. Oh, sorry. Okay. In other words, it appears like. Okay. In other words, it appears like W's birthday was free from activities, so an 8 to 12 slot that day would have been better for him when he is fresh from his overnight sleep. But Bri received a 10 to 2 in the middle of the day. In the middle of his main nap for the day instead. Nevertheless, she soaked up her 2 visits with W last weekend and wore the same sweatshirt for the entire weekend because it smelled like, oh, for God's sakes, because it smelled like W from him taking naps on her at the visitation center. This lady, Jesus. She appreciated that John wrapped W's gifts she sent home with him from the visitation center, then sent her videos of W opening them on OFW, and she cherishes the cake smash pictures John sent on OFW too. So there you go. I appreciate that. That's good. I'll take that. We need more of that. Number 12. We firmly believe that the Discord back to Discord. Sorry, we firmly believe that the Discord channel that we want to subpoena under blah blah order will illustrate that John has continued to bully and harass Bri on and her inner circle online, and has encouraged his followers to do the same in real life. Last weekend, Bri was swatted while shopping for W's birthday presents at the Dallas area Walmart while she was alone. Multiple uninformed police officers approached her and said they received a call that she had warrants in Texas. Of course, after a few minutes of speaking with her, okay, first of all, that situation was absolutely horrible, but that didn't come from that. They were in her life, and I've said this so many times. They actually do need to do a reverse check on whoever did do it. They said they were going to do it. The police were there 5 minutes after they said it, but they also gave her a lot of really bad threats. So they need to look into who said that. That had nothing to do with him.
I'm missing like several pieces. Is Brianna's attorney saying that that he did this? That 2K did this?
Yeah, she's saying that he did it, or that he's telling people in his Discord to do it.
Oh, Lord have mercy.
Right.
Sorry, I hope that didn't offend anybody. Oh my gosh.
She's subpoenaing the Discord records. So she's blaming that on him and the Discord. But again, well, she was on live, and it was really a nice live. That was one live I actually watched of hers because I was seeing such a different person, and she seemed so happy to just be in there. And I was really mad when I saw the police were called. I thought it was just horrible and disrespectful. I did a video on it, but then I saw someone had done a video that was in the chat and watched it, and someone put in there just minutes before they came that said, "I'm calling the police on you. I'm telling you have warrants," but then went on for several other messages, and they were terrible threats. Terrible. To where I felt like her safety was in jeopardy, but that didn't come from John. He was live at the time. How the hell would he have known? He wasn't even in Discord.
You know what's interesting though is but if Brianna, like I could see if the police wanted to subpoena Discord, but I don't see Discord responding to a civil subpoena. This is a civil case. If she issues a subpoena for Discord, they're not going to respond. I mean, I do that stuff all the time. I mean, even sometimes banks don't respond until, weeks after your hearing. I mean, it's like, I can't imagine Discord responding to a civil subpoena.
Well, and I'm trying to figure out, like, what would that have to do with anything? Because, like, now she said in a couple numbers up, she's bouncing all over the place. She doesn't keep it consistent. But she says that she's like, his Discord is filled with middle-aged women, and he speaks to them like he once spoke to Brianna and their relationship, and this should not be allowed. I'm like, why does that have anything to do with the court case, with their custody case on who's in his Discord and how he talks to them?
It's just a bunch of gobbledygook. It's 90 pages of crap,
Yeah, very much so. Okay, let's see here. Okay, number 14. Oh wait, did we do this? She wanted to extend her weekend. Wait, did I stop? Hold on, sorry guys. Oh no, okay, I was starting on number 13. Okay, number 13, supervised visitation logistics. Prior to Brianna's visit with W last weekend, which John declared be at a visitation facility only, Miss Budnick said via email that if the visits went well for her client would consider future visitations to occur outside of the facility. The visits did go well, and the reports are attached as Exhibit G. So we're requesting a set schedule to get the parties through the next hearing date for Keeping the Peace LLC to be named professional monitor company, and for Bri to be able to pick the visit times on visit days listed on her request list. So again, that was granted. So it's a 7-day period. She gets to pick. She doesn't have to do all 7 days. She can do whatever days, and I think she put in the request for 4 to 6 hours. Without these strict logistics in place, we are concerned about facing continuing difficulties in trying to arrange these visits through John's attorney. Just to get an agreement from John for Brianna to see W over his birthday weekend, it took us several days to get a yes to Keeping the Peace, and I had to repeat to counsel at least 4 separate times that the monitors with this company are all off-duty officers. No, you didn't have to. You just chose to keep repeating your damn self. Anyways, this was a company on the original list of 4 that my office vetted and called, and we sent to counsel on 4/16. Once we had an agreement, it took John several extra days to submit his paperwork. We then could not get John to agree to giving Bri any visits beyond 4/26 while she was still in town. She wanted to extend her weekend stay to be able to see W more and attend his first well visit and ENT appointment that week with John. And all of this was denied by John. He did offer her FaceTime to attend the visits, and she missed one of those because it was during her flight back to LA. No, I do agree. I think that it needed to be clear. I said that when I read the first one. I said that the rules were not very clear, whether it was with a visitation like monitor or in a visitation center, because those are grouped together as one.
Yeah, but that was confusing
to
attorney. That's not confusing to attorneys. That was 2K's attorney playing on the form. That's just the form. It's on every form. You don't have an option to select one or the other. Yeah.
Yeah, but that's what I'm saying is that I think that that could be confused. I could see why Bri was saying no, it just has to be a professional monitor, and why John could be saying no, it has to be at a center. So I like the fact that now it's wrote out. These are the days. She gets to select the times. She gets to select the place, and then that's just when it is. So it's not going to be confusing. Well, at least it should be.
Yeah, but I do see though how, I mean, so she's saying she gets, the baby all the way for a whole week, and it looks like that to me too. It just has to be professionally monitored.
But it was only requested 4 to 6 hours a day.
It doesn't show on the order.
Yeah, I didn't see that either. It said, but it also says though that you have to have, it has to go by Keeping the Peace, has to go by their rules. I can't see them doing an overnight visit and just.
Oh, they won't. They surely will not. Yeah. But it could be. I mean, yeah.
And can you imagine the expense of that? Jesus.
Oh yeah. I mean, yeah. But I can see how she's. It doesn't say anything about one of the attorneys drafting another order, so I'm guessing this minute is going to drive until August. Didn't I tell you guys? I was like, oh, it's going to be a long time out, and they're going to need multiple days all together.
Yeah.
So.
Oh, they only do 7 a.m. till 9 p.m.? Oh, that's good to know. Okay. So 7 a.m. to 9 p.m.
Oh, okay, yeah.
Yeah.
I still don't think she'll do the whole week, but yeah.
Oh, yeah, I can't. I don't either. We calculated out with just 4 hours. If she had 4 hours and 7 days a week, it was almost $5,000. not including
Dang.
airfare, transportation, food, all of that stuff, and that's just 4 hours a day. So it'll be interesting to see what happens.
Dang.
Okay, let's see how many numbers we have. We still have several pages to go, so I'm gonna keep reading. Number 14, detailed procedural history. From 5/15 to 12/3/24, my client was represented by Thomas Sands of the Sands Law Group, APLC. From 12/3 to 4/15, my client was self-represented. Bri is a 24-year-old influencer internet personality with no legal training. She has not been working with any paralegal or law firm in her background and has been trying to manage this care herself for 4.5 months before I was hired, which obviously did not go well for her. Of important note, there has never been an agreement between Bri and Ms. Budnick's office for electronic service. I feel like she had this in like every other order too.
Yeah, but it's an issue. I agree she should continue. Yeah, because it's a problem.
Yep.
I don't know how, I actually don't know how they overcome that, but I mean, well, that's not really true. The thing is they've had a status quo pretty solid for a while now, so that's how you overcome it. But if they had their hearing today, but yeah.
I don't know. Nevertheless, nearly every pleading and order that exists from 2025 has been allegedly emailed to my client per the various POS on file. As to the 3/17/24 order that the later kidnapping RFO John filed was based on, there is no POS on file at all showing that orders were ever served to my client. I feel like I remember seeing a paper come out that said that she had marked electronic service, but I don't remember if I saw an order on that, but I still feel like that wasn't very clear. I felt like they still should have served her. But on the other case, the times that they did try to serve her, she kept dodging the service, remember?
Yeah, but there's been no order. People are saying that, but they're getting confused because what happened is the attorney is filing the proof of service saying that they e-served her, but that's not her agreeing to it.
Yeah. Okay. Number 15, an unrepresented party must provide express consent to electronic service by serving and filing a notice to all parties or by providing affirmation consent through electronic means with the court or the court's e-filing provider. None of this was ever done in this case. The only POS on file from 3/17/25 hearing date and the 3/24 ex parte kidnapping RFO filing date is one stamped 3/24/25 at 2:30 p.m., which only lists the ex parte RFO and orders that were filled that day, served improperly, via email on Brianna again. Number 16, to date, the only response from John to the procedural/service issues in this case came by the way of a footnote in Ms. Budwick's 4/22/25 responsive declaration to our ex parte RFO. She argued that because Brianna signed a FOAH for the 3/17/25 hearing, she contested to electronic service. There is no law or local rule that supports this position whatsoever. As explained above, the CCP requires a filed and served notice, a stip-in order in how this is usually done. RE, consent to electronic service, or Brianna's consent through electronic means to the court. She's so wordy. Which can be done through a court form. Equally important, Bri should have never been asked to sign the FOAH in the first place because she was not at the 3/17/25 hearing.
That stands for form of order after hearing, by the way. So just in case anybody wanted to know, that what happens is the judge will generally issue a minute order and then will say that the petitioner or whoever, usually it's whoever won that hearing, their attorney will draft the order. And so then the other side has to sign off on if they agree to it or not. And What's interesting here, though, is it sounds like her attorney is now conceding that she did sign it. If you will recall, one of her first declarations she filed was that Brianna did not sign it.
Right. Yeah.
So that's interesting.
So a quick breakdown of what this order is, or what the order was, just really fast because I don't want to keep stopping. I've done it like 50 times. But so visitation is set. The court dates are set out. She does have to have supervised visits. They set it up for 7 days a month. And she gets to select they have the monitor, but she gets to choose the location, but it's not free willy, right? It says in the thing that she has to choose a location. She has to give them 24 hours or 24 or 40 hours notice of where it's going to be, and they'll provide the service.
Do you want me to read it really quick?
Sure.
It says, pending further order and pursuant to the agreement of the parties this date in open court, respondent is to have professionally monitored visits with the minor from and it gives several dates, May 10th through May 17th, June 20th through June 26th, July 3rd through July 10th, August 4th through August 11th. Visitation is to be monitored by keeping the peace or other such professional monitor as agreed by the parties. Respondent may select the number of hours and locations in Dallas County for visits to take place. Respondent is to provide at least 24 hours advance notice of the location to petitioner. Respondent is ordered to comply with the rules set by the monitor. So I actually think that removes 2K's ability to tell the monitor what he will allow and won't allow, which is good. Courts should not allow the other parent who has the control to control.
Yeah, I agree with that too. And I think she only put the no streaming for medical procedures, which I thought was crazy.
Yeah, neither party is to live stream. Yeah. I think that was at issue immediately because didn't she say she was going to?
Yeah. Yeah.
And then 2K is ordered to notify respondent of any medical appointments for the minor. So that must have been an issue too.
Yeah, it was. All right. All right. Here. Okay, let me keep reading them. When only one side appears, that party's attorney will be instructed to give notice and e-file for the FOH. The FOH form 31724 was e-filed by counsel in the same e-filing envelope that contained the kidnapping RFO, meaning all of these documents were e-filed on 3/24/25.
So that is slightly relevant though, but I don't think most people will understand. So there's a system that attorneys use to e-file documents, and each set of documents that you e-file is called an envelope. So you open the envelope, which is so you open the envelope and then you open the case and then you add documents like motion, request for order, declaration, form of order, proposed order. And so what her attorney is saying there is that in that same envelope, so they filed all of these things at the same exact time, even in the same envelope. So that's why it's relevant, just in case anybody wanted to know about that.
That's why we love having you here, because a lot of those things will fly over our head. And so we love that you're here to be able to chip in, come in and let us know. And just for anybody who may not know or have not been here, AA Law Talk is a practicing family law attorney in California. So she comes in and helps us out. And so it's always a blessing to have her with us while we're going over this stuff. Okay, I'm going to keep reading because then we'll be able to get done. So we can start the party. A week after W's birth and after being absent the entire pregnancy on 5/3/24, John filed a request for a DVRO requesting sole legal and physical custody, monitored visitation to Bri, and protection for himself, his mother, and W, claiming Bri bullied him online. His request was denied entirely and set for hearing 5/24/24. Less than 2 weeks after W's birth on 5/7, John filed a reverse move away RFO asking for W to come live with him in Texas full time. At the first hearing on 5/24/24 on the DVRO, the parties agreed to continue the DVRO trial to 7/19/24 and stipulated to adding John's move away RFO at the same hearing date. The RFO request the RFO requested an order prohibiting Bri from posting about Winter while John was actively posting about Winter. Or W, sorry. Number 18.
Wait, what was
Okay.
that? What did she say? She said that respondent was not allowed to post, but 2K
Yeah.
was?
It says this RFO requested an order prohibiting Bri from posting about W while he was actively posting. So there was no order saying that she could or she couldn't post.
Right.
There was no order
Oh,
saying he could or couldn't. He just requested it and then he posted. So there was no order saying he couldn't.
okay, got it, yeah.
Yeah. Okay, number 18. On 5/31/24, 1 month after W's birth, John filed an ex parte RFO, custody and visitation, which was denied the same day. He requested joint legal and physical custody, disclosure of Winter's medical information, and use of Our Family Wizard, the OFW app. The minute order noted that court would not change custody on an ex parte party basis, or the basis absent. Wait, what? Oh, here we go. I was on the wrong. Sorry. Not change custody on an ex parte base absent showing of immediate danger or risk of harm. This may be heard on the 7/19/24 calendar. After my client allowed John to come witness W's birth after being absent the entire pregnancy and bullying her online for those 10 months, he left Bri alone in LA to care for W as soon as they discharged from the hospital and buried her in litigation within the same month. The 7/19 trial date was moved to 9/17/24 due to the ransomware attack on LASCS. What's that?
Oh, ransomware. There was like a internet hacker. The system got hacked.
Oh, oh, you're kidding. That's crazy. So yeah, I think a lot
But
of
that
people are
was a
wondering.
while ago. They're in 2024. She's still in 2024. She's still
Yeah,
she's still
yeah,
talking about that.
we're all the way back. That's what she says. She says the 7/19 trial date was moved to 9/17 due to the ransomware attack on LASCS or SC systems. But a lot of people were wondering why he requested visitation so early. And I think that there's a multitude of reasons why. Shortly after W's birth, she was leaving the baby with a nanny or her friends. There's many videos come back that she is completely inebriated and they're trying to wake her up and tell her she has to take care of baby W. She was at night. These are her words. I'll still say allegedly but she said it, that she liked to play in the snow at nighttime, but that's okay because he can sleep. So yeah, I think he had just cause for filing. I think as a parent, whether you're mom or dad, just because you're the mom and you're the birth giver doesn't give you a higher right. As both parents, they have to do whatever is best in their child's best interest to keep them safe, even if it's from the other parent. So,
Well, are you talking about his first filing a couple days after he was born, or are you talking about the DB
no,
or restraining order?
the one that's like a month after or 6 weeks after.
Oh yeah.
From what I understand, the one that he did a couple days after was just for him to have like 50/50 visitation.
Yes.
And then once he started seeing the videos of her being out, and there was one video that I thought was horrible. He was only a couple weeks old, maybe a month, maybe if that. And they were at a fair, and she had one of her random guy friends taking care of baby W, and she was completely inebriated the whole time. I would be concerned as a father. I would be very concerned if I'm watching my child's mother do
But the
this.
thing that's so odd, yeah, I don't know. The thing that's so odd is he doesn't actually say that in his DVRO request. The main request was regarding him being doxxed and that time when they were when she like I think threw her gum on him. Do you remember that? And she was like recording the visits. Like that's what that filing was about. So I agree with you that that is egregious, but that's not what he filed about.
Yeah, no, I agree. I
So
might
I
admit, see
don't,
it.
it's so confusing.
Oh, hold on,
Like
I do want to
why
touch on this
wouldn't
really
he?
fast. I don't know. Thank you, Tatted Angel. If anyone is okay, if anyone's in here and is is even comparing Bri to Casey Anthony. You either need to stop or you're going to get blocked. You have to go somewhere else. There is absolutely no comparison to Bri and Casey Anthony. Now, listen, I'm always going to talk about what's right is right, what's wrong is wrong, and that's wrong. Like, I don't think that she would ever intentionally harm her child whatsoever. That's absolutely unacceptable. I'm not going to have people in here just completely disrespecting Bri like that. I don't agree with her parenting style, but I don't see that she would ever do anything like that. So we're not going to talk like that over here, please. Thank you. Yeah, that's way too far. She would never do something like that. Come on. Okay, let me keep going. Number 19. Yep. Okay, after Jennifer Lynn. Oh, I hate the name. I need to go through and cross these out. John's mom and John took the stand on the first day for the DVRO trial on 9/17. John Kitchens, who was assigned to C, asked for additional briefing re the First Amendment as it related to the DVR public figures. The court also put a 225 schedule into place. This is worth noting because John has claimed that since Brianna gave birth, that she was an unfit mother, both online and in all of her pleadings. Yet after a day of trial and 5 months into the case, the court put a 50-50 schedule into place, attached Exhibit H. And that's the 9/17 minute order. Well, he can't control the outcome. What is he trying to say? Hold on.
Well, the thing is that, like I was saying though, is what he's asking for doesn't end up lining up with what's actually happening. Now it is. I would say now it is. And I don't know, strategically speaking, if it was just because he had not established a paternal relationship with the baby yet, not to any fault, not of his own, fault, but so it's possible that they were trying to, you also have to build a case and give them an opportunity to fail. So, but some of the stuff doesn't line up. It could also be that the attorney wasn't comfortable representing that to the court too. So that's all stuff that, is completely possible. But I think what Bri's attorney is saying is basically, if this were the case and if there was these, fear for, DV, that you need a restraining order for, then why would you be okay with 225 is
Right.
what he's saying.
Gotcha.
Or is what she's saying, sorry. But I agree with you too. I mean, I don't know that they would have even given him more. It was a brand new baby, and I do think at the time she was nursing.
Yeah.
So
And I think he was fine with it. That's what he wanted the whole time. He never wanted full custody. He wanted to do 50-50. If you guys missed it, I'll upload it to my YT as well. He only went for full custody because of what all of the actions that took place, especially come November and December when she met up with Santos and all of them, and then she went really downhill. And when they were doing the 225, she kept giving him more time. She wasn't picking him up, or she would ask him to take more time so she could go and do extra vacations and go different places, etc. And that's how they ended up with the 1 week on, 1 week with Bri, 3 weeks with 2K, was because that's what happened during the 4 or 5 months that they did the 225. That's what it ended up being, is they calculated up that time, and he was with Bri for 1 week a month and him 3 weeks.
yeah. And so that's okay, so that makes more sense to why she ended up agreeing to it, because I couldn't figure out why she was agreeing to it, but you're right. There was already a developed status quo outside of the court's order of 225 where John had the baby much more. Yeah. Yeah.
All right, we have a few more. We got just 2.5 pages more to go. On 10/30/24, my client still did not get to take the stand because John's testimony took up the entire afternoon. So a third day of the DVR trial was scheduled for the following day, attached as Exhibit I. The DVRO never continued in front of the court on 10/31, and instead, parties and counsel reached a stipend order to dismiss the DVRO in exchange for John getting primary custody of W. My client will testify that she did not want to settle for W being with John 3 weeks in Texas and with her for 1 week in California. but her prior counsel encouraged her to do so due to the risk of the presumption against joint legal and physical custody. She never gave up W, but listened to her attorney out of fear she would lose W if she lost the DVRO trial. Knowing that Brianna had DVRO allegations and evidence against him, John's calculated move in bringing the DVRO for bullying, while he continued to disparage Brianna online, then hold it over her head to obtain a settlement for primary custody, seems very calculated, attached as Exhibit J. I will say, this is one thing, and again, I'm not an attorney, I don't work in the court system, but my clients who have never had a charge before, they very quickly, if I don't get to them before they get to taking a plea deal, they will plead out really fast to something they may never have done. Just the fear of getting any time sitting down. You know what I'm saying? So I can see how that could have been. I don't know, because again, I do criminal stuff, not family. She's like, you stay in your lane. You do criminal stuff. I do family. I'll shut up, Angie.
Sorry, no, I'm not saying stay in your lane. I am not saying that. I am just saying there's stuff we don't know. And I said that, I think, like on one of our first lives, that whole thing was odd, but there's stuff that we don't know and we'll never know because it's attorney-client privilege. And her attorney now is strategically trying to play on this to suggest that she somehow had incompetent counsel, which she did not. Her attorney was not incompetent, but it must have, I do think it had something to do with the status quo, and I think it was probably pretty likely based on the additional briefing that the judge requested that it would have been granted because she exposed his contact information and stuff. So
yeah, I don't know. Yeah, and I'm not saying that she did agree with it for that reason. I'm just saying that I've experienced that, but a lot of times my clients don't have counsel at that time. It's just the random person that's there. Granted, it's counsel, but and again, my people are sitting down for a while, right? It's not about their child. It's a little bit different. Okay. Did I just read this one? Oh no. Okay, so I'm on number 21. On 1/15/25. Oh God, finally, we're finally in the year 2025. John filed another ex parte RFO to modify the 1031 stipend order by requesting that Brianna exercise her visitation in Texas instead of LA. He alleged this was due to Winter getting RSV and 2 ear infections in 3 months, which he blamed on the travel. He also alleged that Brianna exercised some of her time with W in Texas in November, which I know did not generate any kidnapping motions. Bri was not represented at the time and thus did not file a responsive declaration. The 115 ex parte order on the LASC attorney portal signed by Judge Nord said, until further court order, all respondents' visitations shall occur only in California. During the visitation, the minor child cannot leave Los Angeles, Orange, or Riverside, or San Diego counties. Attached is Exhibit K is 115 ex parte RF order. It does say that, but then if a doctor orders that the child can't fly, what is this supposed to be?
No, I know. This is another thing that everybody hates me for, but
no, we don't hate you. We want to know. That's why
yeah.
That's why we for it. We want to know.
Yeah, so here's what happened. So 2K went to court. The judge heard him on the issue. So the judge heard him say, hey, the doctor's saying don't fly. The doctor's saying this. The doctor's saying that. And the judge, this is where it gets, Bri's attorney likes to use the word sticky. It gets sticky right here.
And
muddy. Because the judge heard all of that and then said, okay, you still need to come here with the baby, like to California. I say here, sorry, I'm in California, so forgive me when I say that. When I say here, I mean California. So the judge did say you need to come to California with the baby, but because he has some issues with the health and, all of that, we are not going to let her, Brianna, travel. And they even restricted it to counties in Southern California so that she couldn't fly to San Francisco, still be in California, right? They clearly
Yeah.
did not want her flying with the baby at all because of the health issues. But the court, knowing all of what it knew, which is what he presented, which was that the doctor said not to fly, what I would guess, or what I would probably bet some money on, is that the doctor didn't say that. The doctor probably said, and again, this is something we won't know. This is stuff that is private in the filing system, children's health, medical stuff. Sometimes it gets filed as declaration attachments, but for the most part, the court's pretty good about redacting all that. But um, what I bet occurred was that the doctor said, 3 days after antibiotics start or something like that, which is what we see more often than not. But
Yeah.
the court did not care that the doctor said that. And I know that people don't like to hear that, but he still had a responsibility to get the baby here. I don't care if he drove. I don't care if he flew. I don't care if he took a train. I don't care if he rode a bike. I mean, I do care if he rode a bike, but the point is he needed to figure out a way to get the baby here. And part of the reason why judges are so are so strict about that is because the court allowed him to move. The court said, yes, you can move with the baby and go to where you want to go, but you are absolutely responsible for getting the baby here for visitation. And so the judge was not compelled to say that you don't have to come here or that she has to go there. And again, I know that okay, I want to say this as gentle and as like loving as possible to honestly to both Bri and to 2K. But for people who say, well, he was going to pay for her flight, he was going to pay for her, Airbnb, he's going to pay for this, even if you agree or disagree that there was any form of abuse from any side of the party, allowing one party to have that source of control, we'll call it, can just cause more and more damage. So I know that people like to say, oh, well, he was offering this, he was offering that. And I think the offer is, I don't know, is it good? Is it an attempt to control? I don't know. Are there arguments on both sides? Absolutely. But he was 100% responsible for getting the baby here, and he didn't want to do it. And where it gets really tricky is then his attorney, right after this, which I think we'll go through in this declaration, Brianna's attorney will probably get to it, but his attorney was like, oh, wait, you guys made a mistake, court, because you said that our ex parte was granted, but it wasn't. And then the courts get so confused and so bogged down, and they have so many cases that then they ended up entering the order that said she couldn't leave Texas. So you'll get to that in this declaration, but yeah, that's the problem. It's a problem.
Yeah. No, it makes sense to
So
me. Okay, so number 22. On 1/16/25, John filed an RFO on the court's regular calendar asking to correct the 115 order.
yeah,
John argued Judge Nord must have made a mistake in the order signed on 115 and and said surely the court meant the opposite than what was written, i.e., that visitation was only to occur in Texas. The hearing on the RFO was set for 3/17/25. On 1/21/25, John filed another ex parte FRO to shorten the time or advance the hearing. On the 1/16/25 RFO that was sent for 3/17/25, this ex parte RFO was also denied for insufficient showing for immediate harm as defined by leaving the 3/17/25 hearing as is. Thus, between 1/25 and 3/17/25 hearing date, the order available online stated Bri's visitations were to be in California with W. After Ms. Budnick told Bri after the 115 hearing that they are filing an ex parte RFO to correct the orders, Bri heard nothing further from her until she reached out herself on 3/6/25 to ask what was happening.
yeah. I mean, this is a problem, but
I wonder why she
really,
waited
when
2 months.
no, I don't. Well,
Like, no, I'm saying, why? I wonder why Bri waited 2 months. Like, when it got close to the time for scheduled visit, I wonder why she didn't reach out. I'm not saying that that's good that she didn't get it. I'm just curious on too why she didn't.
well, I think she just didn't know what to do. And this is procedurally complicated. Right here is where it gets like a procedural disaster zone. Um, and it was wrong. Honestly, I mean, I hate me or love, but what the
We
court
love it.
did was wrong. Her visits should have been occurring in California with the restriction that there is no leaving. However, um, a court cannot um, harm or not harm. The court cannot now say, oh, we made a mistake, so we're going to make visits be back here because now just too much has happened. Like, in other words, you can't, just because the court was wrong doesn't mean that you can now put the child in an uncomfortable situation for, you know what I'm saying? Like, there's been the way visits have been occurring now for this long. Anyway,
Yeah.
the court essentially can't right the wrong that they did to Bree. It doesn't really matter at this point, you know?
Yeah. No,
So, but it was wrong. So,
hey guys, we listen. We may not agree or we may not like it, but she knows the law better than any of us. She's a practicing attorney out there in California doing family law, so she knows what it is that she's talking about. Again, we all may see on another side and be like, "Oh my gosh, you couldn't fly because of this," or whatever the case may be. But again, there's regardless if we like it or not, the law is the law, and it has to be filed with however it is stated in the court. The court document stated that it had to be in California. Even if on the behind the scenes they had agreed to something else, it does say that in California that her visitations were to happen in California. So, okay. Okay, number 24. At the 3/17/25 hearing, that was the one that you guys were talking about earlier that were in when she was in Miami. She said she didn't go because she was in Miami. Okay, this is this court date. My client did not appear or file any pleadings beforehand, as noted in the 317 minute order, opposition not having been filed. The court granted the request and ordered for all Brianna's visits with W to occur in Texas. The parties were also ordered not to disparage each other on social media. There is no POS on file of service of this order on my client. The 317 FOAH was filed alongside the 324 kidnapping RFO and was later unconformed on 4/3/25 attached Exhibit M. I cannot say for sure without receipt of subpoenaed evidence from beyond 324 encounter with police, but I assume there was mass confusion on behalf of the police and my client due to there being no enforceable order in place about visits occurring in Texas.
yeah. So do you remember when I said, I think that you and I got on a live together and I said the minute order isn't enforceable.
Right.
And 2K's attorney was responsible for drafting an enforceable order and she didn't. She just didn't until it was too late. And so then in a flurry, she submitted an order and then appear anyway. So
I
yeah.
wonder why did the judge if she wasn't served, right? And she didn't know, even though we heard her read the file. And again, you guys, that's where it's different, right? Yes, we all know that she knew the order, that she had the order, but she still was not formally served, right? But why would the judge then sign the order for the pickup and for any officer to be able to
Well, they
go
didn't.
ahead.
That's why it took so long. I mean, do you remember how upset 2K was getting? I mean, I mean, it took a long time. Didn't it take like 2 days? It took like 2 days for them to do that. Usually, if you have an enforceable order, then you appear in court and you get a writ of assistance or an order of assistance, or, you get the order saying, hey, this is what's going on. But his attorney had to appear twice. So his attorney had to appear, get the judgment signed, and then that says visits are only to be in Texas, and then get another order, an abduction order. So that's where the abduction order came in, and
Mm.
then the
I
police
thought it
were
was
able to pick him up.
I felt like it was quick though. I felt like she only had him like 36 hours. And
That's
the
a
order
long
was
time in a situation like that, though. When
well,
you're,
true.
yeah,
True.
Yeah.
Yeah, it is a long day. And then she had to return them at noon the next day, and she said she wasn't going to go, etc. So, anyways,
Yeah,
we all
and
get
so she ended up just burying herself, right? Like she was
right.
like, oh, she could have been like, okay, now I know, so now I'm gonna do this. But she was like, well, he didn't serve, he didn't this, and then the court just like, oh, get out of here. You know, at
Right.
that point, and I think I told you this too. At that point, does service really matter? I mean, it does matter. I don't want to lessen it, but you know, she was very aware, you know, of what was required from her.
Absolutely. Yeah, and I think that's her downward spiral just continued at this point. Okay, so we're almost done, guys. On 3/24/25, John filed um, sorry, another ex parte RFO claiming Brianna kidnapped Winter, or W, sorry, per the 317 orders. Brianna was ordered to not remove W from Dallas County, Texas, and for all visitation to be professionally supervised at dates and times coordinated by the parties based on the monitor's availability. In a minute order specifically directed that a FOAH be prepared, which was the case on the 317 minute order. The minute order is not. What the hell? Look how tiny
Oh,
this
this
is.
is what I just said.
Can
Yeah.
you read that? Look how tiny this is. How is my blind self supposed to read that? Can you read
Oh,
that last page for me?
twelve
If
point
not, I
five.
can.
Oh, I don't have it in front of me.
Oh, that's okay. I'll use my phone and just blow it up. I don't know how the heck I'm supposed to read that. Here we go.
But she's basically saying what I just said. That the minute order, I can pull it up too.
I got it right here. Okay. Um, Considered final until the FOAH is filed and signed by the court. Southwest Law School. Oh, I don't like to read all that stuff. You guys don't need all those little numbers.
My I would say my biggest issue with that form of order is that is where he got legal custody. And I know people are like, "Oh, it's not marked," and yeah, it is. That's where he got legal
Yeah.
custody.
Oh,
And the court did not say anything about legal custody. So
okay, here we go.
anyway,
It is very unfortunate that such inflammatory language was used in this 324 RFO kidnapping, with full knowledge that an FOAH had not been submitted to the court until the same day. This RFO was filed a full week after the 317 hearing. On 327, John filed another DVRO based on the kidnapping allegations, and he repeated his online bullying allegations. This DVRO was also denied in its entirety, like the first one was, except for the order not to AB. W and John's mom were again not listed as protected parties. The order is attached as Exhibit N. I declare under penalty and perjury of law in California, these are true and correct based on the best of my knowledge. And that is the total declaration that Bri's attorney submitted yesterday. Was it yesterday? Yes. It was yesterday. So that is it. Thoughts, questions, suggestions? Where are we at?
I just wonder why it's a little odd that she keeps filing the mass declarations to me because it sounds like this is like her trial court memo.
Right.
So I'm
Yeah.
like, what?
I don't know. Yeah, she's a different one. And
But that's okay.
I'm genuinely curious on if Bri's attorney like watched any of the stuff that Bri did, like that day when the police were there for hours and they were mocking the police and just doing all this stuff with Baby W. I wonder like if she watched any of that stuff, like if she actually really knows what's happening with the whole situation, or is she just taking what Bri says at word? And we know that oftentimes what Bri says, there's not a lot of truth behind what she says.
Yeah.
No.
Yeah,
No.
she's a rage baiter. So there were a couple questions.
Okay.
One was, is the minute order from today enforceable? And no, I mean not really, but 2K it's really ordering 2K to comply with things, you know. This is really for, there isn't, well, okay, let me back up. There isn't anything that really needs to be enforced. So if 2K doesn't provide the baby for the visits, he will look very bad for court. He won't do that. So, and really, she's not in any position to even enforce parenting time anyway. Um, so there really isn't much to enforce. So no, not really. And then if she live streams something, well, then the court should, I mean, it's just, again, it looks really bad for her. So the minute order is valuable, it's important. It gives the parties direction, but is it enforceable whereas somebody can take it to a police station and say, hey, I need you to enforce this? No, not at all. Not at all. I mean, it's a valid order. It has to be followed, but it would have to go through a different process to be enforced, a
Yeah.
contempt process. So, and then somebody else said, "What's next?" Like, what's next? Nothing. They wait until August.
Yeah, they have to go through the. If you guys are just coming in, you guys didn't see the very beginning. So today, what they did is they scheduled for the evidentiary hearing, the trial hearings, and then they set weekly visitation for Bri in Texas, supervised. Everyone still keeps asking. I tell you guys, I wonder how many people would be passed out right now if we start playing the game on time. So even though she said that she has unsupervised visitation and she can go wherever she wants to and whatnot, that is not true. She still has to use supervised visitation through keeping the peace. She has to provide the location, the one location, and the times that she wants 24 hours in advance. She can see him for all 7 days, right? It'll be those her time slots for 7 days, or she can see them. She can see him 2 days. She can see him as many times as she wants to in there. I know her attorney, it's not in the minute order, but the attorney did request for them to be at least 4 to 6 hours in time. Keeping the peace only does visitation between, I think it's 8 a.m. and 7 p.m. or maybe 9 p.m., something like that. Okay, just hold on. Let me get through this first, okay? So we have to get through that, right? So she's going to have visitation during those hours for whatever time she wants. And again, she has to pay for it. It's like $165 an hour or something like that. And she has to pay for those times as well. So that's what happened today. No overnights. They don't do overnight visits. And on top of all the stuff that was put in the order, it also has to be applying. They also have to, what's the word? I'm losing my word. Comply. They have to comply with all of the visitation center's rules as well. So whatever rules the visitation center has, that has to be applied too. So if that means that they don't allow phones for streaming pictures, all that kind of stuff, she's not going to be able to stream anyways, but then they can't. Even if 2K says, yeah, that's fine with him, and Bri agrees, but the visitation center says no, then it's a no. So that's kind of what they're...
Yeah, and I think also what supervisors don't have availability like all day.
Oh, where'd she go?
Oh, sorry, I'm here.
Okay.
Can you hear me now?
Yeah.
My battery low when whatever that thing came on. But I don't know where it cut off. But the supervisors don't have availability all those times too. Like it would be great if she could figure out a way to get the baby maybe 4th of July in the evening or something like that so they could do fireworks. But it depends on if the supervisor's available or willing,
Right. Yeah,
So
it has to be on when, if they're available. She can submit the times. She has to give them 24 hours advance notice, and then they will fill in. They'll fill in where they can. But yeah, she still has to. No one else can come to a supervised visit, you guys. Those are just standard rules. You can't have anyone else around.
I think it's up to them. I don't know. This is a lot of supervised visitation. It's possible that like Bri's mom could come or something. Like there are some supervisor, and I don't know about these, so I don't know. But sometimes there are rules, like after your third visit, that and with the approval of. But I think the court removed 2K's ability to really put restrictions on it. But it's possible her mom could potentially come. But I don't think like random people like.
Right. I
These
think
people like Santos isn't going to be able to go on a visit,
no.
with him.
Yeah,
So,
and they do have the order, I believe, that was a while back, that, or maybe it was in the October order, where I don't know, one of the orders, there was something put in there where the other party couldn't introduce someone that they were dating for like 6 months or something, some type of rule. I feel like I remember seeing in there somewhere.
Yeah, but those are
But
like there's a lot of stuff in court orders that like don't really matter. That aren't That's one of them.
yeah,
Nobody has ever to the dawn of time been able to enforce that in California.
yeah, and
But they
I
put
just
it in
can't see.
there.
Yeah, I just can't see a monitoring center just being okay with just with Santos. That's just not going to happen, you guys. Um,
They won't
yeah,
allow that for sure. But like a family, like a true family member,
yeah,
then I could see that being a possibility. But I could see that after like a couple of good solid visits. I do wonder, I did anybody wait, really quick, did anybody else from this chat join the call? Because it was a remote hearing. Did anybody join?
oh, I don't know.
Because I'm curious if there was an issue with her not following the rules at the center because they specifically said that in the order. So I'm curious.
Well, Jen just commented that Keep Peace does not allow visitors beyond Bree. Nope, not
Yeah,
allowed.
I mean,
No family members. Oh, okay. Yeah, so I guess it's one of those things that I guess that's why they put in there. Not only do you have to follow the rules of the court, but you have to follow the rules of the monitor center. And again, this is the monitoring center that Bree chose. So
Bree's attorney chose.
right, Bree's attorney chose. Yeah,
I don't know if she even realized. Like, anyway, that's funny.
I don't know.
It was a good choice, though. I think it's a good place. I think it's a good
Yeah,
place, and I think that this order emboldens them to be able to control the situation instead of,
right.
you know.
Yeah, definitely for safety. Okay, I'm gonna let Leah come up really fast.
Do you want me to drop?
No, no, no,
Oh,
no. Stay up. If you're comfortable with staying up,
yeah.
I'd like
No,
you
I'm
to.
good.
So I was the one with the question about the minute order because you had recently or previously said that the minute order that was placed back in March, I think it was, about how the visits had to be in Texas and she couldn't remove the baby, technically couldn't be held against her because his lawyer didn't file a different type of something or other that was signed by the judge. But then that's why I was asking, is this minute order that was just released today, can that be enforced as far as like she doesn't have to go to the visitation center and she can go to the Airbnb, or could she just all of a sudden like try and get him to the Airbnb and not have a monitor there because there isn't like an actual court order? I guess it's just a minute order.
Um, so that's a good train of thought. I see what you're saying, but no, the supervisors won't allow it to get to that point. So the supervisors will follow the minute order. When I say the March 17th order wasn't enforceable, I just mean you can't take it to the police to get them to enforce the order. Um, in terms of like kidnapping or custodial interference or anything like that, which are those charges that people keep asking about. When that's why she's never been charged, and she will never, ever, ever face any charges or anything related to that because it wasn't that because there was no order, enforceable order. But I see your train of thought, but no, the supervisors will follow they won't allow any need for it to be enforced. Does that make sense? So like they're not
Yeah,
going to be
so
like, oh, this isn't enforceable, so she can go ahead and leave. Like the supervisors will be like, yeah, no, that's not a thing.
okay, so because the order placed and signed by a judge happened what last month or whatever, saying that her visits moving forward have to be supervised, they will continue to have to be supervised until otherwise signed and dotted saying different, correct?
Yes. Yeah. Well, yes, but they changed it a little bit. They just modified it slightly. But yes, you're correct.
Okay. Yeah,
Yeah.
I was really confused on that. And then was there anywhere did because I heard her say that John had requested a certain type of test to be done, but I haven't seen that in any of the court paperwork.
I haven't seen it either. I think I know. Well, I've heard a lot. I've heard evaluations being requested. I've heard tests, for substances being requested, but I haven't seen any of that either. I think he may just put it in declarations and say like, "Hey, I think this needs to happen. I would like to have a mental evaluation because of this, this, and this." But there's no formal request in front of the court for that.
Okay, that makes sense. And then my only other question is, I know that supervisors sit there and like they watch you closely. However, how often has it been historically in all cases that a parental figure could essentially up and leave without, like, and just take off and the supervisor?
I've never seen it happen.
Okay, so I
Especially with
know.
this one. This is all done by off-duty police officers too, so it's definitely
Okay,
not happening. It's not like when other places you may have an old social worker like me sitting there, and maybe they'll try some fun. They're not going to get far, but still, this is all active off-duty police officer. She's not going to get nowhere. That's not going to.
And
That would be the worst. Like that would just she would never get sued. That would be crazy for her to even attempt to do. You know.
and
well, at
that
this point, I
actually
kind of
would
put nothing past her, so.
well, I mean,
Right.
true, touche. That would actually qualify for an Amber Alert too. Um, so I think I've heard of one case, but it wasn't one of mine. This is a CPS case, where a parent tried to ditch the CPS worker, and I think actually successfully did. They were at a fast food restaurant, and
No, you guys. Sorry, but I don't want to get a. Okay, hold on, you guys. I want to make sure that nothing funny gets out because I only want legit, like literal information out. She was given a hypothetical situation. Bree has not
oh,
broken
sorry.
any. No. They're asking because Leah said, could she get away? Like, what would happen? So people now are saying, oh, did she break any rules? No, she has not broke any rules. She did great on her 2 visits that she's had. So I just want to make sure that that's clear that we're not from my channel. It's not coming out that she's broke any type of rules. Leah was just giving a hypothetical situation to see if that what would happen if that happened. So I just want to make sure we're good.
Well, and I was just asking about any type of supervised visit for anyone
Yeah.
in the United States. It wasn't even about her specifically.
Yeah,
So,
I know what you meant, but I just saw that question come up. So before somebody ran with it, I just want to make sure that we cleared that up.
And I'm sure that it has happened and that it happens from time to time, but it is not a frequent or regular thing by any means. And she won't do that.
and then the only other question I had, and then I can hop off, is you had said something about the courts made a mistake and they won't right their wrongs by right the wrong that they did by Bri, but I missed it. So can you just repeat whatever that was?
Oh yeah, gosh, somebody in the comments said it so much better than I did. But basically, like the best interest of the child cannot be put aside to right a wrong to a parent. I'll just say it like that, right? Like, so even if the court did make a mistake in signing the visits to only be in Texas and then set this sort of train off the tracks, so to speak, they can't now go back, and it would be harmful to the baby too. Well, obviously for obvious reasons, but you know what I mean? Like they wouldn't be, they can't. So family courts are a court of equity, which essentially means that, like, okay, yes, they may have done something wrong, but they still have to consider the best interest of the child. And you can't just undo all of that to make it right, you know?
So
So
how would moving the visits to Texas be doing wrong by Bri?
I'm sorry. Oh, well, that's what set the whole dumpster on fire, because she then went to for her visit in Texas and then took him to California. So, if you look at it from a perspective of, well, the court, was it even a valid order? I could argue on appeal that it was not a valid order. And so essentially every order after that would be considered moot because it wasn't a valid order that they were trying to enforce and operate off of. Um, but even still, even if the Court of Appeals was like, oh yeah, that's right. That's a correct, position to hold. They can't then just say, oh, well, baby's back in California now for visits. You just can't do that now.
Okay.
So I hope that made sense. If it didn't, let me know. Sorry.
I mean, it does and it doesn't, because on one hand, you're saying that it wasn't a true court order, it was just a minute order. But then, like, at least in
Well,
my head, but then it was kind of a true court order, just like her having supervised visits wherever she chooses to versus it being at a visitation center. That's only written in a minute order. So I don't understand how one is more
that's not what
correct.
happened. That's not what happened. So what happened
Oh,
is the court made an order saying that her visits had to be within Southern California. And then 2K's attorney was like, "Oh, we made a mistake. They're only supposed to be in Texas, not in these counties in California." And the court didn't know, and Bri didn't show up. And so the court signed it saying that visits were only to be in Texas. So the wrong isn't that it was a minute order and it couldn't be enforced. The wrong was that the court's order was very specific that parenting time was to occur in California, but only within these counties in California. And then when 2K and his attorney appeared in front of the judge, Brianna did not show up. And as a result, the order saying that parenting time was to only occur in Texas, and then that's when it all just went to poop. I
isn't
would
that
say
kind
the
of
other way, but
normal though? Because I know, like,
no.
back years ago when I was going to court for custody of my son and we were like doing child support court, like when his dad did not show up, they granted me whatever I
Oh,
wanted because he didn't show up. So,
yes. Oh, yeah. Well, that is normal. You are right. But okay, so yes, that is normal. If you show up, it's then generally called like default. It's not a default in this case because she's appeared in the case already, but essentially it's default. She didn't show up. Yes, you are right. But what
well,
Brianna's attorney was just filed with the court yesterday, and what Angie just read, the attorney was saying that all Brianna heard from 2K's attorney was, "Oh, we're going to go ex parte to correct the order." So, and because Brianna's not an attorney, she had no idea what was really going on. Now, I'm not justifying. I think she admitted to being hungover and sleeping. So I'm not, none of this is me justifying her behavior in any way, but it is absolutely, like, as a matter of fact, like, it was wrong of his attorney to do that. Like, I think there's a very potential for a complaint, but that I wouldn't want to be a part of if I was that attorney, because it's not okay. It's a complete misrepresentation to the court. And as it stands today and all of these other hearings, 2K's attorney has an ethical obligation to correct it and still has not. And that is a problem. So anyway, that's a whole other separate issue, and it doesn't justify any of her actions. It's just, that's not what the court ordered. That's not what the court ordered.
do you think it
So
would have turned out different for the March 17th thing if Bree had showed up to court?
5,000%.
Absolutely.
All
But
she
I
So,
had to do was show up.
also want to say though, really fast, we're going off on a lot of what ifs, and that's how misinformation gets out. I want to keep my page strictly to facts, because I'm getting a whole bunch of questions now of people wondering, like, they're going all over the questions, and I like to stick straight to the facts, just so that we don't get no misinformation. I never want any misinformation to come from my channel. I just want it to be facts. I love all of the questions, and you're making all of the sense. It makes sense, but it's confusing people. So I want us to not do a bunch of hypotheticals. But yes, and AA Law Talk and I talked about that right before the last hearing. We said, just brief. You listen to us. That's the only thing we listen to us. Just show up to court. It's going to make all the difference. Because if you don't show up, it's just granted to the other party. So it absolutely would have.
right, yeah, I was just really confused on the whole thing. That's why I'm asking these questions, because if I'm confused on it after listening to you two, like, read the documents and say what you guys are saying, I can only imagine how many other people are just as confused.
Well, and you listen, you're not alone. The court's confused. The attorneys are confused. I mean, once a case starts to look like this, it gets really hard to untangle.
Yeah. It is the whole thing is confusing. And again, because I grasp it because this is a minute order and the other one was a minute order, and we said that one couldn't be done. Now I feel like in here, I'll read this minute order again. You guys, this is the minute order from today. Okay, I'm going to read it to you guys for anyone who just came in. Nature of proceedings, request for order, hearing filed, and it says who all came up. The matter is called for hearing. All parties appeared via LA Court Connect. The matter is set for evidentiary hearing on, and gives the dates. I don't like to give the dates because I like to have some type of privacy for them. Briefs to be filed by 7/18. Then I give a date. Counsels are to meet and confer regarding exhibits and evidentiary hearings. Neither party is to live stream any medical procedures of the minor child. Petitioner, which is John, is ordered to notify respondent of any medical appointments for the minor. The court set the case for trial readiness conference, and then pending further order. So that's what it says here. So this is stating it's pending further order. We're going to stick with what's in here, right? And pursuant to agreement of the parties, this date is open court, and then it gives all of her visitation dates. Again, I'm not going to mention that here because, again, some peace. Visitation is to be monitored by keeping the peace or other such professional monitor as agreed upon by the parties. Respondent may select the number of hours and location in Dallas County for visits to take place. Respondent is to provide at least 24 hours advance notice of the location to petitioner. Respondent is ordered to comply with the rules set by the monitor. That's all that came out of today's hearing. So I want to make sure that we know she has followed the orders from the supervision center, keeping the peace. She does, I know she has said multiple times that she can just have baby W and do whatever and not have it supervised. That's not correct. She does have to have visitation still. So that's all that came out of today and all of the dates. And then she just has the 7 days, and she can choose. She can see him every day out of that 7 days for a few hours each day, or she can choose just a couple of days. It's truly up to her. So hopefully that helps clear things up. I think some people came in the middle. I think maybe that's where some of the confusion may have came by.
Yeah, there isn't really anything to enforce in this. The other order, Leah, to your point, is enforceable, which says supervised parenting.
Yeah.
Awesome. I mean, I truly hope that her alone time with the baby really kind of brings her to that point where she's like, okay, this is all this other stuff is not really what I want. This time that I have right now is what I want. And she completely makes a 180 and just soars from there. I mean, that would be the best case scenario, is for that to happen. And that's truly what I hope for. You know what I mean? It's just what's best for the baby. So
I hope so. We can all, hope and pray that's what happens. I was really hoping after her first visit, remember when she said that she had 2 hours, no phone, no interruptions, just her thoughts. And I was like, oh my gosh, are we seeing a breakthrough? I did a video. I was like so excited. I was like really proud of her. I was like, maybe that's what she needed. And then nope, as soon as Santos and Vale got in, she was out partying that night. So anyways, I don't know. But I will continue to hope.
I know that in her declaration, she did mention that like when she's not with him, she just kind of feels lost in the sauce in a sense. So I feel like all this stuff is kind of a distraction, but hopefully having this time where she can't have that distraction, she can't have the people online being mean and talking crap. I think it will, I'm really hoping that it will kind of bring that out more and more. And it's a lot of time that she'll actually have without that outside distraction. Hopefully that will make a difference.
We can hope so. Okay, hold on, because I want to clarify again. Visitation has to be done by keeping the peace. So she has to have a monitor. She gets to choose which days out of the 7, there's only 7 days in the month that she's allowed to see the child. In those 7 days, she gets to choose which days and hours she wants to see the child. The visitation has to be done in Dallas County. And she gets to choose the location. So maybe like if she wants to take them to the zoo or something one day, or the library one day. I don't know. Again, that's going to go based, I think, off of the visitation center, what their rules are. But it does have to be up to her. She gets to choose dates and times and locations. It has to be in Dallas County. There will be no alone time, and there will be no other people coming into visitation with her. And there'll be no streaming. So I want to make sure we're finished up with that. If anyone missed anything, I will upload this to my YT channel as well, so you guys can see that. But I want to make sure that was out. No streaming. She won't have her phone. And yes, and she has to pay all expenses. Okay.
And if they go somewhere like the zoo, I don't know if there is one in Dallas. I'm sure there is, right? Anyway, she has to pay for the supervisor, and they usually have, like mileage costs and so just.
Yeah, I think someone did read that too, that there was a mileage expense. So yeah, anything that they do, she has to pay for. So can they go to an Airbnb? I don't see why not. I mean, I don't know. Again, I think that would be up to the visitation center. So again, now this is, in my opinion, is always real. Just like AA Law Talk. Sometimes her opinion is not liked. Mine is not always liked either. Personally, I would rather it be in an Airbnb or like an actual living type situation. That's where we get to really evaluate a parent on how they can actually parent, right? How we're able to manage, cooking their meals and doing all that stuff. Whenever we go out places, she's going to be able to prepare and prep all of that stuff all on her own, or, when she doesn't have a child that she has to take care of and watch as well. So personally, I prefer them to be in real life, living type situations. Not saying that a zoo or a library or something isn't, but there's just more to do. So personally, I prefer them, but it's going to be up to the visitation center, I think, on that.
And it allows the supervisor to give good notes too, like couldn't turn on the stove, or I don't know, whatever. I remember that vividly happening about the stove. So,
and the electrical things. Remember, he kept trying to put like his fingers and things in the electrical outlets, and she's like, "Oh, just stop doing that." He was like 7 months, 8 months old. I'm like, "Girl, you don't understand. You got to move away from there."
Yeah, so they'll be able to really visualize, how the corrections are happening, if they're appropriate. Anyway, it'll be good.
Yeah.
I just want to say this because I've seen someone comment in here. Are Bri's current actions or distractions great? No. However, that does not mean that if she puts in the work, she cannot change. People change all the time.
Yeah.
Addicts change all the time and become amazing parents. So there is a possibility there for her to make that change and be the best mom that the baby could ever even wish for. Just because she's making mistakes now does not make her a horrible person. It just makes her mistakes bad. She has the ability and the opportunity to make that change.
Absolutely. And again, that's something we'll always wish and pray for. That's one thing John says all the time too. He wants that. He wants Bri to be in W's life. He wants 50-50 custody. He's never wanted to have her out of his life. So I want to answer a couple of questions. Does it still apply that she has to be sober within 12 hours for a visit? Yes. What happens if she cannot afford to utilize supervised visit and or doesn't see him as often as she can? If she can't afford it, I think then I don't know actually California how that would go. Here we usually going to see him.
California have what? Does California have what?
She was asking what if she can't afford to utilize the supervised visitation center?
Then she doesn't have a visit.
That's how it is here too.
I mean, yeah. John can agree to another supervisor, but I don't think it would be wise to do that, and so she won't have her visit. But I will say that the court, wants to see her make an effort. So even if she does one day during that 7-day period, if she truly can't afford it, or there's some reason, whatever, then the court will take notice of that. But they just want to see her make the effort.
Yeah, she can definitely afford it. I think people just ask just like what if that's an excuse, or what if she says that or whatever. Yeah, she can absolutely afford it. And again, she gets to choose the days and times. So maybe one day she'll do 6 hours, and the next day she'll do 2 hours and then skip a day. Angie, can you please get AA Law Talk to explain how it will affect case if his lawyer corrects?
Oh.
Corrects what?
I don't. Yeah, the error. If the.
Oh, yeah, going back.
I don't. No, yeah, I don't think it'll do much because, I mean, it's important to do, because I think that actually puts them on an even playing field when they go to court on the 22nd. But like I said, the court is a court of equity. They can't really do much now because, well, one, so much other stuff has occurred that, is glaringly obvious that it wouldn't be a good situation for the baby. But really, I mean, really, it would just be good for both parties, honestly, at the hearing on the 22nd of August.
Oh, hold on. Give me just 1 second. Hold on. Oh, I didn't mean you guys couldn't talk.
Oh, sorry.
No,
I'm like, you got me in a chokehold. I'm afraid something's gone on with you.
No, it's just because one of my clients just messaged me because today was supposed to be my last day because I retired. But then I said I'm going to stay on because I had 3 guys that I need to get into something. So anyways, so he just messaged me. He's like, I missed you. I'm sorry. He's like, I hope everything goes good. Blah, blah. So I just let him know that I'll still be there to get him going on Monday. But then Monday's going to be my last day for sure this time, guys.
I thought you said Tuesday.
Well, it'll be... I'm hoping Monday. I'm hoping I'll be able to get everything done Monday. Tuesday will be the absolute positively latest that I will stay on.
Speaking of your retirement, how did you get so lucky to do so gracefully and early? Because I need to learn how to get there.
Listen, I have a 2K in my life too, okay? My daughter then said, Mama, it's time for you to sit down and be a grandma. Come out here and live on my property and take care of this baby for me. But I also started my career young, guys. I started working for the state when I was 21 years old. So at 41, I had and I started early on where we had like a Piers 1 retirement plan. So you get 20 years in and you got full retirement benefits. No, I won't touch my retirement at all, right? Until, I'm much older. So my retirement's just been sitting and growing and growing and growing. I haven't been with the state for over 10 years. So it's just been growing. And then I've had this for my job now for 10 years. So I have retirement there too. So I'll be okay. Yeah. And then, like I said, my daughter has and her husband have a beautiful property and I'm going to take care of their baby. And so it'll be a blessing.
Brandy had a question. It says, is the monitor judging her question mark, like grading her parenting? I guess that would be something AA Law Talk or...
Yeah, I mean, I wouldn't call it judging, but they do monitor to watch to see what are you doing? Is she, when the baby's fussy, like, is she attentive to the baby? Does she know how to deter like all the different cries? Is she able to soothe them? Is she able to take care of them? Does she have all the necessary things, right? Does she bring diapers and wipes and enough food for the amount of time that they're going to be there? All of those different things that you would need, they're going to make sure that all of that stuff is done.
I know in the court docs that I had read, it was like 10:01, baby did this. 10:02, mom did that. 10:03, baby was still doing this. 10:04, no change in activity. So
they watched the whole thing. Yeah, it is intense. That is for sure.
I will say that they're not judging though. But
observing.
What makes a good parent supervisor is one who doesn't judge, because you really have to try to make the parent feel safe and comfortable being in a very not embarrassing, that's not the right word, but being in a very I don't know, disadvantaged position. Yeah, uncomfortable. There you go. So, that's
I like how Lisa said it. They observe what's going on, not judging, but they just kind of write down the facts, Yeah.
We did go over this, but I've seen this a lot. AA Law Talk. Can you explain again what you said about the Discord? Because everyone keeps asking about the Discord. Are they going to be able to do something with that? The courts be able to do it? What's your thought?
I mean, they're going to try, but they're probably not going to be successful. I don't see companies like Google, Discord, Verizon, AT&T, all these companies that really have a lot of data about like messaging and private messaging. Even Facebook and Instagram, they, for the most part, do not respond to civil subpoenas. They do for criminal cases, but even then, they often will fight against that as well. So I don't see them getting any information from Discord. I don't think anybody needs to be concerned. And I will also, can I say my opinion about this, Angie? I don't want to make your page. I think that we have read several times Bri's attorney saying she's not playing to the court of public opinion, but she absolutely is. And her firm is watching these. I think I've said that before. And that information in the declaration, I would confidently say, is for public. I think they want people to be concerned. I mean, part of that strategy maybe comes from a good place, right? Like not wanting people to think that it's okay to dox her while she's with the baby. So I think an attorney throwing out there about a subpoena happening and getting the information is just highly unlikely. Now, if the police wanted to do that because of the swatting incident, that's different. But even still, I think Discord would fight it.
Really fast, I just want to say something. I don't want this to come off the wrong way, but I just got a text message from my daughter that sent me a message that she just got via TikTok DMs. If you guys need to get a hold of me or want to ask me a question, please do so through me. I have 2 pages on here. I also have a YT, and also my email is up there, but please don't contact my children and ask them to unblock me. Or for me to unblock you guys. Like, leave my kids out of it, please. Like, that's not okay. I grasp that I'm behind in my orders and stuff, but please don't contact my children. Please. That's a way to not get unblocked. Especially because there's multiple ways to get a hold of me, and I'm in the midst of a live. And I grasped that this person was just trying to be nice and just say, she said it very nicely, like, hey, I just got blocked from Mom's live. I know this is weird, but can you ask her to unblock me? And so, anyways, she just sent it to me, but that's just, please keep my kids out of it, please. That will be my kids or grandkids getting involved in anything I do online will be the fastest way for me to delete my entire platform and never come back. I just won't do it. So if we could just all be respectful of that, please, I would surely appreciate it. Yeah, boundaries. There you go. Thank you. Boundaries. Yeah. Right.
That is not okay.
Yeah. So anyways, my daughter's so nice about it. She's like, hey, Mom, someone sent this to me about an hour ago, but not okay. Don't contact my kids. Okay, are we done with this court stuff? Can we move on to the party for a little bit, or what? It's not really a party, but we're just gonna kind of hang out. Yeah, I just think that. So I don't know. I would never think about that. I would never think if I was online, like, well, let me just contact our kids. Like, I know a lot of you guys follow them, and I love that. They don't ever post or come on here, but I love the fact that you guys just follow them and support them. But yeah, that's just weird. Yeah.
What's
right.
the party?
Yeah. Oh, yeah. Hold on. There is other people. Hold on. Sorry, I forget all the time. Oh, okay. Hold on. I'll let you guys up, but we have to try to make this quick, if that's okay, because I do want to try to move on. We weren't supposed to do this today, but
do you want me to drop so other people can come up?
Oh no, there's enough time. If you're fine with staying up, I just want there's 4 people that can come up. I'll let those 4 people come up, and that's it. Okay.
I'm good. I just don't want to. No, I don't want to rain on a party. Okay.
No, you're good, girl. You're part of the party. We'll have Laura go first. I'm gonna just do it in order of how I let them up. Okay, so we're gonna go Laura, then Colleen, then Amber, then Jeanette.
Thank you. Okay, so can you hear me okay?
Yeah, I can hear you.
Okay, so obviously I have decided like I'm not either side any longer, right? Because I think it's really silly because it's really what's best interest for Winter.
Right.
But I was really thinking today because I watched a lot of like playbacks and clips of people posting her with Santos and the twins yesterday about how like, just literally eating her apart. And I watch people's eyes and stuff and, she's broken. Okay. Bottom line, broken. But it also, I feel like comes down to everybody expects all of these things from her. You need to do this, but how if she was never taught from it? Like, you can clearly see that when, you parent the way you parent, Ange, right? I parent the way that I parent. And yes, I don't want to say that it's an excuse, right? Because I came from a very broken home and I became a really good mom, but some people just don't have that, right? They just don't have it.
But
So
shouldn't she have taken the parenting classes
she
and the
should. And look,
conflict
I'm
classes
not
she was supposed
disagreeing with that by any means. I'm not. But I do feel like if she gets away from these distractions, she gets away from these people, because we've seen what she can do in the beginning. She was not like this. If she gets away from these people and she makes the room to want to be there and present, like I really feel like in her mind, because I don't know if anybody saw this, but her wanting to get pregnant again and saying all these things that she's saying, it's almost like she is literally trying to replace what has been taken from her. And it's it's like she's already set her mind to the fact that she's never going to see her son again, and that is sad. That is sad. I don't care what this girl has done at this point. That child does not deserve that. And everyone's saying a skit, a skit, a skit. I don't think so. Like, I really don't think that this part that we're at right now is a skit.
You know, I think I've always said that too. I truly believe that she does love Baby W, and I'm sure she does miss him, but she has to step away from the substances.
Yes, and that's
I,
what it has to come down to.
yeah, I say that all the time. Like, I love, you know, when she had that 2 hours of just peace and quiet, and she says, I really just got to think. And I was so hopeful that she would continue that way, but nope. As soon as Santos and Valet came, all that went out the window, you know, and then she was
And like
back
this is and money is like a drug, right? Money and
right.
and the
Remember,
fast
don't
life.
make sure careful with the words. Careful with the words.
Sorry. And that's also like that's also like that, right? And then now that Santos did what he did with his child, it gives her more of like maybe like, okay, I don't feel so bad now. So like that type of mentality is just not good. And so you're dealing with two different people. You know, I don't know 2K well, and I only know what I see. And I don't want to judge anybody, okay? Because I feel like I have definitely judged and I am not
Bedrest, how
one to
can
be
I help?
judging. I just feel like, okay, my question here is, after everything I'm saying, is it possible, do you guys think that she will get anything back after everything has been done? Because the discord that everyone's bringing up, they could just easily say that's rage bait, right?
What do you mean? Is she gonna get anything back? Are you talking about
Like,
like
do you think
supervised
she's gonna, do you think she'll
visitation?
get any type of custody again? Do you think there will be any type of like structure, routine where
Yeah,
she will have Winter again at all without
that's
being, and I know it's
right.
her choice, but do you think a
Right.
judge is going to,
Well,
without like slowly
it's
lift the
literally up.
supervision, I
It's
guess?
gonna be up to. It's gonna be up to her. It's gonna be up to the way that she. And AA Law Talk and I went over this
Because I
before.
just feel
So
like
what
she's
happens?
not going to fight Anne, just what I feel
Well,
like.
hold on. Let me explain it to you though how it goes. Right. So she gets this visitation time. Right. So you start in the spot that they have run. So the first step was for her to do her first two visits. She did that. So now she's taken a step up. Right. So now
Right.
she has this 1 week and she gets to do her supervised visits how she wants to. As long as she makes every step, then she'll go up to the next step to gradually. So she has now until August or whenever the trial is to prove herself again. Now, the first time she messes up, she's going to go back down to step one. And so she's going to start over. So, yeah, there's absolutely, until the final order is done, there's always a possibility she can get it back. It's literally based on what she's going to do, if she's going to do the work. So,
Right.
she could absolutely get some visitation and rights back to him if she does the work.
And before you boot me, what is this stuff that's going around the Discord? Like, were people really going after, like,
I don't think so. I don't know. I haven't seen it, and I don't
have Discord, so I wasn't sure.
John is very much don't contact. Like, I just can't see him like telling people to do it. But I don't know, and I wonder how they would even be able to prove it if it is. And again, it's the same thing. She does the exact same thing to all the time. She's always like, "Well, go over to his lab and go tell him to do that. Go tell him to let me do this. Go do." So, I think that's going to be a moot point. I think it's going to be a wash. But I don't know. I'm not ruling it.
All right, well, thank you. Boot me, because everybody and the little ones that are in the comments getting upset about having a headache.
Oh, you're fine. You're fine.
Oh my gosh. Thank you.
You're welcome, Bob.
Hello.
Hi. What's up?
Hi. So, quick question. This is about, when she took the baby when she wasn't supposed to. Besides the fact that she read it on live, I was a leasing agent and I would go to court, and if my people didn't show up for their evictions, like, they still had to leave within the 10 days. And like with criminal court, like if somebody doesn't show up, they get a warrant. If they get pulled over, they go to jail. Like there was no like. Well, I don't understand why it's she didn't get
Well,
served
because
properly.
it's every law is different, right? Thank you, Black Widow. Every law is different, and so I think in this situation there is a part of the law. And I think AA Law Talk did a great job of explaining it that you are required to be served with the information. Right now, I do know that she was also dodging serving, so I don't know, and that was all recorded too. So I wonder how that's going to be. But that was after the fact of the initial one that she missed. But again, you guys, if she would have just shown up to court on March 17th, I don't think she'd be in the same situation she's in right now.
No, that was all my question. I just didn't know if, like, at what point is it her responsibility instead of all these loopholes that she keeps getting through.
No, I agree with you. I'm right there with you, girl. I'm right there with you.
All right. Well, thank you.
You're welcome, love. All right, Amber.
I saw some comments about people having some concerns about her being on quote unquote her best behavior at the visits because they're supervised. And coming from a foster parent who took kiddos to supervised visits all the time, I just want to make it clear, at least in my case, it was a DHS case, so kind of different as far as the supervision goes. They are trained to find those little things, and you can only conceal it for so long. My bio parent for my kiddos was a diagnosed narcissist, and they could easily, to the public present very likable and well. And even then, in our visits, the little things were always caught and documented. And so, yeah, she might be on her best behavior. It might not be a full picture of, who she is as a parent on her own, but it'll definitely at least paint that picture.
Absolutely. Yeah, and that's why they have to use a company. They need to use a professional because they're trained and they're certified through the state in order to do these supervision. So they're trained to look for all of those little different things that they do, the body language, the motions, seeing if the parent is getting frustrated with the child because of whatever, not being able to pick up on the child's cues or whatever it is. It'll all come down to, as you guys heard, they document almost like a per minute, thing. Now I've never gotten a report that detailed, but it's very interesting.
Either. I've never seen that detailed either.
Yeah, no, I haven't seen the visitation thing, but I mean, in my 30 years, I've never seen one by the minutes. But anyways, so yeah, they'll pick up on that. So Amber is 100% right on that.
Absolutely. I just wanted to add that comment, but you can boot me.
Thank you, love. Okay, Jeanette.
Hi.
Hi, how are you, love?
I'm doing well, thank you. How are you? I
Good,
just have a
good.
question. Well, I live in California, right? And
Mhm.
that whole situation where she brought baby W over here, is she not getting is there no consequences for her on that or
No, yeah, she.
Oh, wait.
Okay, go
The
ahead.
consequences are profound. And the
Yeah.
consequences are that she is on supervised visitation only to occur in Texas. And if people don't see that as a consequence, we have some bigger issues. That is a
no.
profound consequence.
Yeah, but I mean I to me it's I is there no charges? I would be scared if I were her.
No, because she wasn't invited. No. She had
No.
joint legal custody at the time.
Oh, so because okay.
Yeah.
Okay.
Yeah.
All right.
She could be held, they could file a contempt action against her. California, that's a quasi criminal, so she could potentially face jail time for something like that.
Mhm.
But Chigue's attorney hasn't done that, and it's really not that reasonable in this situation because of the consequences where she is now only supervised visits. So,
Oh, got it. So the court never got moved to Texas.
oh,
It's
it won't.
always it won't. Oh, okay. So
It won't.
okay.
It will stay in California.
Mm. All right. All right. Thank you guys.
You're welcome.
Bye bye.
Right, bye. All right. Are you guys up? There's a couple more people, even though I said I wasn't gonna let anyone else up. I'm gonna put you guys down. Are you guys up? A Law Talk, are you up for a couple more questions? There's three more people.
I'm here. I'm here. My
Okay,
kids
so I'm
are
gonna
in
do
bed.
these
I'm
three.
here.
Okay, I'm not gonna take any more requests. I'm gonna do these three people, and then that's it. We're gonna move on to my retirement party. Okay, so we have Mar. You're first.
Hi, is there any drug testing required for
Oh,
this now?
you guys, when you guys come up, please make sure you guys watch your words. Rug testing, rug. At this
Oh,
point,
my bad. I'm so sorry.
that's okay. At this point, there is not any that I saw. Did you see any AA Law Talk?
Oh, I thought I was on mute, so I was trying to unmute, and then I
Oh,
ended up muting myself. Okay. No, there isn't. That's not a. I have.
Interesting.
Yeah, it's not. I've heard her say it though, but it's not. Um,
Okay, that's all. I don't want to keep y'all waiting long.
oh no, you're good. Yeah, I know a
Sorry.
lot of people have asked that because I know that they asked it before, or it got brought up before. Maybe some people had wondered, but at this point, there's nothing. That's not to say it won't come later, but at this point, there's nothing that says that it's required.
Right. Thank you.
You're welcome, though. Yeah. All right. And the other one's dropped off. Okay, so we are done. So just a quick recap. We went over, and I'm not going to go back over it. I will put this up on my YT channel, but we went over Bri's attorney's declaration. I just felt like it was a bunch. It just went back and kind of recapped everything. And then for today's court, all they did is they scheduled out different court dates for the trial and the evidentiary hearing, and then set up for Bri will have 1 week a month with supervised visitation using I've said it a million times. Why did I just blank on the name? The same company she used last time.
keeping
Up
the
to
peace.
6 hours a day. Yeah, keeping the peace. Thank you. I don't know. Somewhere I had wishing in there. I don't know where that came from. I think something wishing for my retirement party. And then it has to be supervised. Has to be in Dallas County, and all the other good stuff. So there are no overnights. She has to pay for everything. If she goes somewhere outside, like a activity or whatever, she has to pay for the supervisor, and she has to pay for everything. I don't know. Oh, and the other thing is, they have to agree upon it. Her and John. Well, they don't have to agree upon the date. She has 24 hours to provide him the date or the time and date, and then she also has to follow whatever supervisory rules that they have. So there we go. Whatever the company has, she has to follow those rules too. So there we go. That's the recap. Well, howdy, partner. And I will put it up on my YT when I get off tonight. So there we go.
All right. You want me to drop so I can listen to the party now? I don't know how to drop this. So you're
Yeah,
gonna
I
have to
can.
drop
I can wish down. Here we go.
because I'm gonna listen to you.
Oh, she was still talking. Oh my gosh, I kicked her. Oh god. Leah, do you wanna drop down or?
Yeah, I'm dropping down too. I was just
Okay.
about to say that.
All right. Thanks, Lum. Okay. Man, that was a lot. Again, AA Law Talk. I know. I was like, wait, what happened? You said drop. Thank you, Colleen. I always love having you come up and share. It's such a great opportunity to have two professionals be able to communicate and talk about this and answer so many beautiful people's questions. I will, Nikki,